Yes.
May I be permitted to obtain leave of this Honorable Court?
Yes.
Lordship, may I be permitted to obtain leave of the Honorable Court to file a first miscellaneous appeal? It is an order from the Shiliguri Court, Your Lordship.
Ms.
The
Ghosh, that is an appellate side matter probably, but please.
and the appellate side and Lordship, it's today Your Lordship is sitting in the single bench,
No,
Your
when I
Lordship.
take up
I apologize.
appellate side matters, please mention then.
Lordship, at 3:30.
Division bench. It's a division bench matter.
Lordship, it's an appeal, first miscellaneous appeal.
So then you have to mention on Monday, Ms. Ghosh.
Lordship, I am only seeking the leave to file it today.
I cannot, sitting singly, I cannot grant that leave. Sorry. Call on.
Lordship, grateful, my lord.
Thank you.
I'm appearing for respondents 3 to 9.
Yes. To be
Lordship-
mentioned for filing notes? Or?
No, Your Lordship.
Milord,
The matter was
had to come back to your Lordship, Milord, to report on talks of settlement. There is one sitting which has happened. It is in the progress, Milord.
So,
So,
Your Lordship kindly keeps it after vacation. We shall come back and give
So I'm
it.
cancelling the part heard then.
No, Your Lordship. Kindly do not, Your Lordship.
Need not. The learned counsel for the parties submit that the talks of settlement are still going on and further time is required to conclude such discussions. Full stop. I find from the record that on October 31, 2025 as well as November 21, 2025, the matter had been adjourned on the same ground. Full stop, next para. Hence, it would be useless to keep the matter pending as a part heard matter. Full stop, accordingly, the part heard marking in the matter be cancelled. Full stop, liberty to the parties to mention as and when the matter is either settled or the talks of settlement fail. Full stop, let the matter go out of the list for the present with such liberty.
Wait, Lordship.
Diplo.
Yes.
May it please, my lord.
Yes, please. Yes, question. Yes.
Apply, my lord. Well, that's in continuation to where we had left.
Right.
I hope I'm audible, Malad.
Yes, yes, absolutely.
Yes,
Yeah.
yes. In addition to Malad, what we had cited before this honorable court on the last occasion, there is one small compilation, Malad, in addition to what we already have, which my colleague would be handing over, Malad, today. It's on a short point, Malad. We are not irrespective of the size of the matter, Malad. The point is short, and I will just take my lords through first, since we left at the aspect of fraud.
Right.
There are certain judgments, Malad, of this honorable court and of the honorable Supreme Court that I had cited in the new compilation. But
Yes.
let us, Malad, first start with the earlier compilation that I had cited earlier, Malad. So we had completed, if my lords will have a look at the index.
Yes, yes.
We had completed, Malad, 3 portions, namely the aspect of violation in 31(2), Malad.
Right.
The patent illegality aspect, both in terms of contrary to the express words of the contract and also any words which can be added to the contract.
Right.
The argument was that it cannot be done because that is patently illegal. That's contrary to the terms.
Yes.
Then, Malaj, we had come on the aspect of interpretation of contract, whether that is within the domain of this honorable court to interfere into, and that there I had cited, my lords, DMRC versus Airport Express, which my lords are very well aware of.
Right.
We had left, my lords, on the point of fraud vitiate solve.
Yes.
So, my lords, before we actually start, just have a look at the section, my lords, 32 or 34 to AB.
Yes.
Just 2 aspects that my lords are already aware of it. My lords do it day in and day out.
Yes.
34, my lords.
Right.
I am on 2B.
2B,
2
yes.
aspects. Yeah, just 2 aspects. B starts with, just a minute. B starts with what is, by the words, the court finds that.
True. Yes.
So irrespective, the submission and also the case law is going to be, Malad, that irrespective of any party coming to court or highlighting something, if the court by itself believes that there is something fraudulent about the award or the means in which it has been procured, the honorable court can interfere.
True.
It need not be that I must always, or we may make a case if my lords also believe, especially on something that is not something which is not meeting the eye, the honorable court can interfere. And also, Malaj, may have a look at the explanation 1, subclause 1.
Yes.
The making of the award was induced or affected by fraud and corruption.
Or yes.
Sorry, or corruption, or was in violation.
Right.
So,
Right.
Malaj, we are on two words primarily, fraud or corruption. And I would also, Malaj, bring in the aspect of bias. Because ultimately, bias is something which is if I can say, Malaj, fraud is the genus, and bias is a species, perhaps, of the genus. So I'll be touching upon on that topic, although of course, Malaj, I have not argued that the arbitrators were biased, because I have not, in my pleading or even while I was addressing this honorable court, I have not stated that a particular arbitrator was biased against me for certain circumstances. But this aspect came to my knowledge only after the pronouncement of the award, which is what which has been the fulcrum of my argument on the aspect of fraud, Malaj. So having said that, Malaj, having put that into perspective, Malaj may straight away come to serial number 19, Malaj, in my first compilation. That is Devas Multimedia, starts at 429.
Right. Yes.
And, yes, 429. The relevant paras are, Malaj, 10, 106,
Yes.
109. And I'm so sorry, Malaj. Is my voice resonating?
No, I can hear it clearly, but
I'm sorry. I can hear some after. I'm so sorry. So, Malaj, 10, 106, 109, 110, and 115 to 22.
yes, right.
Right.
Is some device on at your end, Mr. Chandra? Some other device on at your end? Sometimes that is the cause for reverberation.
It's not logged in, Malaj. I have devices, but they're not logged into this.
No. Then it cannot be a reason.
They're
Yes.
not logged into this this stream.
Must be the system then. Yes.
Perhaps. Anyway, I'm so sorry, Malaj.
No.
Yes.
Yes.
So, Malaj, para 10, this is just to put into perspective as to how the matter came about. I had already, Malaj, explained the last time. Para 10 only, I will not read all of that, Malaj. I'm just going to explain what it was. Para 10 basically states, Malaj, that how a particular company was incorporated for fraud. The NCLT reached a finding that it is fraudulent at page 432, Malaj. In the first compilation, page 432, para 10.
Probably the pagination is not telling with my copy.
Is it so, Malaj?
Yes. Deva starts in my copy at page 433 actually.
Oh, I'm so sorry.
No difficulty. I'll find out para 10.
Yeah, it's internal page 4, Malaj. On top left, it's internal page 4.
Yes.
That page 436.
436. Yes. Got it. Thank you.
Para 10. I'm so sorry, Malaj. It's perhaps the copies may be different, Malaj.
No difficulty.
Same true, untrue, Malaj.
Para 10 starts with while the proceedings.
Yes, Malaj. Yes.
Yes.
While the proceedings under Section 34 of the arbitration were pending, Antrix moved an application before the National Company Law Tribunal Bangalore bench under Section 271C and 271E of the Companies Act for winding up Davis on the grounds that Davis was incorporated for fraudulent and unlawful purpose, and the affairs of the company were being conducted in a fraudulent manner. While an order dated 25th of May 2021, the NCLT allowed the petition for winding up preferred by Antrix, declaring that Davis had been informed for fraudulent and unlawful purposes, and its affairs had been conducted in a fraudulent manner. This order of the NCLT was challenged by Davis along with DEMPL before the National Company Law Appellate Tribunal, which dismissed the appeal by an order dated so-and-so and upheld the order dated so-and-so passed by the NCLT. The order dated 8 September 21 passed by the NCLT was challenged by Davis and DMPL before the Apex Court, and the Apex Court, by its judgment dated so-and-so, upheld the order of the NCLT. It further held that Antrix could not be stopped from pleading fraud and seeking winding up of Davis, even if the plea of fraud was not used to terminate the Davis agreement in 2011, or that it was not raised before the arbitral tribunal as the fraud was discovered much later. Something similar, Malaj, which has happened here. The court stated that it did not find any perversity in the finding of facts recorded by either the NCLT or NCLAT, as they were borne out by the documents which were not challenged as fabricated or inadmissible. The Apex Court further held that the seeds of commercial relationship between Antrix and Davis were a product of fraud and perpetrated by Davis, and every plant that grew out of those seeds, including an arbitral award, would be infected with the poison of fraud. The Apex Court further observed that a product of fraud is in conflict with the public policy of any country, including India. The basic notions of morality and justice are always in conflict with fraud, and allowing Devas and its shareholders to reap the benefits of their fraudulent action would send wrong messages to the international investors, namely that by adopting fraudulent means or by bringing into India an investment in a sum of rupees 579 crores, the investors can hope to get tens of thousands of crores of rupees even after siphoning off INR 488 crores. So, Balaj, even though in the arbitration proceedings, there was no fraud per se, but because the company was incorporated with the purpose of fraud, the court interfered and said that the arbitral award is also tainted with fraud.
You probably have an edge. You have a better case because here in that case it was induced by fraud.
Yes, Malaj.
It was
Yes.
found out later proceeding fraud. I mean,
Yes, Malaj. Yes,
but in
yes.
your case, you did not have any way to challenge on the ground of fraud at that point.
Absolutely, Malaj. Not at that point of
So
time.
it's
No.
affecting the award. Fraud
Yes.
affecting.
Yes, Malaj. Yes, yes.
So you have a slight edge over this case because
Slightly
this
better, Malaj. I'm slightly better placed.
intra proceeding and yours is you discovered after.
Absolutely, Malaj. Absolutely. Now, Malaj, may please have a look at 106, para 106, which is at page, in my page, it may be a little different, Malaj. I will just show.
You can refer to the internal page if you like.
Yeah, internal page 74. Internal page 74.
No, it's not.
But it's 514.
Thank you. Yes, 106 I've got.
Yes, Manoj. The question of power of a court dealing with an application under section 34 of the Arbitration Act to suo to discover grounds of
No. This is not para 106 you said.
Yes, Manoj. The question of power of a court.
No, this starts with at this juncture. I mean, my paragraph starts with at this juncture.
I'm so sorry.
Online.
Just give me 1 minute. I will just at this juncture.
Starts with at this juncture, it would be apposite to elucidate.
Just. Sorry. It's nowhere near Maharaj. I'm sorry.
Yeah.
105. Not even the internal page, Maharaj, 74? No.
Internal page, no, this is internal page 82, para 106. So if
Okay.
it's internal page 74, it's the middle of a paragraph.
No.
95.
Could my lord see Hindustan Construction Company?
Nowhere near this.
Okay.
Uh,
Could my lord just repeat the last, the para it begins with?
at this juncture, it would be apposite to elucidate. This is
Yes.
106.
Yes.
Internal page 82, but it's your copy since your name is printed and the CC online of you.
Yes, my lord.
You must have supplied this.
No, I have supplied. The only difficulty is this may be the true copy. That's the reason why.
Yes, maybe true copy that.
And what I have is a not so true copy, so to say.
It starts at
Yes.
96.
Yes, Malad.
Para
Yeah.
96.
Yeah. What my lords are reading is
That's
actually
page
para 116 in my. Sorry.
96, page 507. madam.
You
The
learn
question of
says,
power of the court.
page 50, that's para 96, he says.
Yes.
The question of power of the
The
court.
question of the power of the court, thank you.
Yes.
That's para 96 in my copy, but
All right. I'll just mark it. And my lords may please just also remember that para because I'm going to come to that para after this. The one that we were reading. Just.
All right.
Yes. So para 96 was there, the question of power of a court dealing with such an application under 34 of the Arbitration Act to suo to discover grounds of fraud and introduce additional grounds to a section 34 application by way of an amendment application even after the period prescribed in the statute has been answered by the Honorable Supreme Court in its decision in Hindustan Construction Company. I'm relying only on the point that the court can also suo to look into it. The other aspect is not really relevant for us, Malad. Now, Malaj may come back to, okay, so this was 96.
At this juncture?
Yes, Malaj, just before at this juncture,
Uh-huh.
there is another para, I'll just tell you, it's 96. 98. Malaj, please see 99 for a minute. Does it start with in both the above cases?
Yes. Yes.
19.
Yes.
Malaj, please have a look at 99.
It's just below bottom of page
Yes,
51.
yes. 99. It starts with that.
Yes, in both the above cases. So two cases, Malaj, I'm not referring to them, but the crux of that is really relevant. In both the above cases, the Apex Court has looked at the language of the provisions of Section 34 of the Arbitration Act and laid emphasis upon the phrase, the court finds that occurs in Section 34(2)(b) and 34(2)(a) of the Arbitration Act. This phrase has been interpreted by the court as an enabling provision, allowing the court, while deciding an application under 34 of the Arbitration Act, to grant leave to amend an application under 34 of the Arbitration Act if the peculiar circumstances of the case so warrants, and it is so required in the interest of justice. The court has held that the phrase enables the Section 34 court to discover on its own patent illegality in the award and set it aside under Section 34(2)(a). It has further held that provisions which enable a court to act on its own in deciding an application under Section 34 would also be available in an appeal under Section 37 of the Act. The phrase "the court finds that," which finds mentioned in both Section 34(2)(b) and 34(2)(a), allows the court to look into the award and discover the grounds mentioned under Section 34(2)(b) and Section 34(2)(a) of the Arbitration Act. Consequently, the phrase enables the court to discover suo motu whether an award is in conflict with the public policy of India. As a corollary, having regards to explanation 1, subclause 1 of Section 34(2)(b) of the Arbitration Act, it follows that the court would also have the power to discover on its own whether the making of an award is induced or affected by fraud or corruption or is in violation of Section 75 to 81 of the Arbitration Act. We therefore find no merit in the submission of the appellant herein that a Section 34 court does not have the power to suo motu discover grounds of public policy or fraud and set aside an arbitral award on this basis. Manoj, may now please turn to at this juncture. That's 99. 104. That would be 104. Yes.
514.
Yes.
Yes.
In fact, but just before this para, let me look at 103. At the last aspect to be considered.
Yes.
The last aspect to be considered is the contention of the learned senior counsel for the appellant herein that the general observations regarding fraud cannot be applied while considering an application under Section 34 of the Arbitration and Conciliation Act without satisfying the ingredients of Section 17 and 19 of the Indian Contract Act. It is his case that a general principle of fraud cannot be applied when there are specific provisions, namely Section 17 and 19 of the Contract Act and Explanation 1.1 to 34(2)(b)(2) of the Arbitration Act, which would prevail over the general principle. At this juncture, it would be apposite to elucidate upon the principles of fraud vitiates all Solomon Acts. As has been expounded through various judicial proceedings, the Honorable Supreme Court in SP Chenga Balaraya Naidu versus Jagannath, speaking about the aforesaid principle, has observed as under: fraud avoids all judicial acts, ecclesiastical or temporal. Observed Chief Justice Edward Coke of England about 3 centuries ago. It is the settled proposition of law that a judgment or a decree obtained by playing fraud on the court is a nullity and non-est in the eyes of law. Such a judgment or decree by the first court or by the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. The High Court, in our view, fell into patent error. Maharaj, please just have a look at the bold portion. The principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of dishonest litigants. The courts of law are meant for imparting justice between the parties. One who comes to court must come with clean hands. We are constrained to say that more often than not, the process of the court is being abused. Property grabbers, tax evaders, bank loan dodgers, and other unscrupulous persons from all walks of life find the court process a convenient lever to retain the illegal gains indefinitely. We have no hesitation to say that a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of the litigation. Following the decision in SP Chirangalaya Naidu in Ramchandra Singh versus Savitri Devi, the opposite court held the apex court held as under: commission of fraud on court and suppression of material facts are the core issues involved in these matters. Fraud is well known, vitiates every Solomon Act. Fraud and justice never dwell together. Fraud is a conduct, either by letter or words, which induces the other person or authority to take a definite determinative stand and as a determine it to stand as a response to the conduct of the former, either by word or letter. It is also well settled that misrepresentation itself amounts to fraud. Indeed, innocent misrepresentation may also give reason to claim relief against fraud. A fraudulent misrepresentation called deceit consists in leading a man into damage by willfully or recklessly causing him to believe and act on falsehood. It is a fraud in law if a party makes representation which he knows to be false and injury ensues therefrom, although the motive from which the representations
The rest of it mostly is induced by fraud.
Yes, Mark. So
In
most of it
fact-
is yes, primarily induced by fraud, but just the concept, and I'll get to the. I have one judgment of this honorable court, Malad, where I'm sorry. Yeah, I have one judgment of this honorable court where the making of award has been questioned, Manoj. I will get to that, Manoj, but so the relevant paras, I will not read all of it, Manoj. 120, Manoj may just look at. In my lord's copy, it is going to be.
What does it start with?
It starts with, it is now well settled.
Yes, 110.
Yes, ma'am. It is now well settled that principle of fraud vitiates all Solomon Acts is applicable not only to primary proceedings, but also to all collateral proceedings that arise out of the same facts and circumstances. The act of fraud is an anathema to all equitable principles, and every transaction tainted with fraud must be viewed with disdain by the courts. Fraud is always viewed seriously by the courts, and any act of conspiracy, any act of conspiracy of fraud or deception done with a view to deprive rights of the others in relation to a property would render such a transaction void of initio. A party which commits such fraud or deception cannot be permitted to reap its benefit, especially by taking advantage of judicial process, including in subsequent or collateral proceedings, as doing so would result in the court enabling the perpetuation of fraud. Such an interpretation would be absurd and would lead to disastrous outcomes. We see no merit in the submission that the principle of fraud vitiates all Solomon Act is a general principle and special provision will prevail over the same. So the argument, Manoj, is rejected here, where it was that fraud is going to be limited to 17 and 19.
Right.
Only that definition of fraud will be covered under 34. Even in instances where the subsequent proceedings or a collateral proceeding pertains to the application of a special provision on fraud, the factum of fraud having been established in a previous proceeding will affect all transactions and proceedings which have been tainted with fraud. In the instant case, the Supreme Court in the civil appeal number so-and-so has held that the commercial relation between Devas and Anthrax is a product of fraud. And as a result, the Devas agreement, the ICC award, and all other disputes arising out of the transaction would be tainted by fraud. Permitting Devas and its shareholders to reap the benefits of the ICC award would amount to this court perpetuating the fraud. Such a view would be against all principles of justice, equity, and good conscience. At the cost of repetition, para so-and-so of the civil appeal are binding upon the learned single judge and this court. Thus, the observations made therein, which are based upon the principle of fraud vitiates all Solomon Acts, are not only correct in law, but also binding upon the learned single judge and this court. We therefore see no infirmity in the impugned judgment, wherein the learned single judge has relied upon para number so-and-so of the judgment of the apex court to set aside the ICC awards. Now, Malaj, may please, just to carry on this aspect of fraud, please look at the second volume that I have just circulated.
Yes.
Because the rest of the judgments for fraud are there, Malaj. Malaj, plus, please see the first one, Venture Global Engineering. It starts with one para 34 and 39, Malaj.
Yes, but it would be better if an index was supplied.
Malaj, the index is there on top.
No, it isn't in my copy.
No index.
In the second volume, no.
No, Malaj, there is an index which has been.
I don't have it. My copy doesn't have it.
Don't have a copy.
I'm so sorry, Malaj. I have, in fact, this index, as it was pointed out the last time, contains the paras also. Could I just
that would be very helpful.
Just 1 minute, Manoj. I'll just how can that be? We sent everything, Manoj, yesterday. Just give me 1 second.
Yes. It can be supplied during the course of the day, Mr. Chandra.
Yes, yes, Manoj. Yes.
Right.
I'll continue. And Manoj, I'll continue.
Continuing the running pages are there, so we can follow
Yes,
that.
yes. No difficulty, Manoj. No difficulty. So, Malaj, the first judgment is Venture Global. The relevant paras are 34 and 39. I'm so sorry, Malaj, I don't understand why it was not sent.
Hmm.
Perhaps some glitch at my office.
No difficulty.
Yes. 34 and 39, Malaj, may please see para straight away. Page, I'm sorry.
34. Yes, I've
Yes.
got.
Yes. Page 11, Malaj.
Yes,
The concept of public policy.
that's 35.
Yes. In view of this, Malaj, we can start, that's where it starts. In view of such varying standards of public policy in different countries, an attempt is made to arrive at a somewhat acceptable standard by construing that something is opposed to public policy where there is an excess of jurisdiction and a lack of due process. The concept of public policy in Arbitration and Conciliation Act, as given in the explanation, has virtually adopted the aforesaid international standard. Namely, if anything is found in excess of the jurisdiction and depicts a lack of due process, it will be opposed to public policy. When an award is induced or affected by fraud or corruption, the same will fall within the aforesaid grounds of excess of jurisdiction and a lack of due process. Therefore, if we may say so, the explanation to 34 is like a stableman in the saddle on the unruly horse of public policy. It is well known that fraud cannot be put in a straitjacket, and it has a very wide connotation in legal parlance. In the decision of House of Lords in Redway versus George Benham, Lord Macnaghten explained the multifarious aspects of fraud very lucidly, and which we quote. But fraud is infinite in variety. Sometimes it is audacious and unblushing. Sometimes it pays a sort of homage to virtue, and it is modest and retiring. It would be honesty itself if it could only afford it. But fraud is fraud all the same, and it is the fraud, not the matter of it, which calls for the interposition of the court. The aforesaid elucidation by the learned law has also been accepted in celebrated treatise on fraud, Care on Fraud and Mistake. Care has also referred to Story's equity jurisprudence and defined fraud as under. Fraud in the contemplation of a civil court of justice may be said to include properly all acts, omissions, and concealments which involve a breach of legal or equitable duty, trust, or confidence, justly reposed and are injurious to another, or by which an undue or unconscientious advantage is taken of another. In Indian law, namely the Contract Act, the said common law doctrine of fraud has been assimilated in section 17 of the Act. The very wide definition of fraud has been given. I'm not reading the section, Malaj already are aware of it. 39. Therefore, this court is unable to accept the contention of the learned counsel for the respondent that the expression fraud in the making of the award has to be narrowly construed. So they reject the point that it has to be narrowly construed, but it must remain wide. This court cannot do so primarily because fraud, being of infinite variety, may take many forms. And secondly, the expression, the making of the award, will have to read in conjunction with whether the award was induced or affected by fraud. On such conjoint reading, this court is unable to accept the contention of the learned counsel for the respondent that the facts which surface subsequent to the making of the award, but have a nexus with the facts constituting the award, are not relevant to demonstrate that there has been fraud in the making of the award. Concealment of relevant and material facts which should have been disclosed before the arbitrator is an act of fraud. If argument advanced by the learned counsel for the respondent is accepted, then a party who has suffered an award against another party, who has concealed the facts and obtained an award, cannot rely on facts which have surfaced subsequently, even if those facts have a bearing to the facts constituting the award. Concealed facts of every nature of things concealed facts in the very nature of things surface subsequently. Such a construction would defeat the principle of due process and would be opposed to the concept of public policy incorporated in the explanation. The rest of it, Malaj, I am not reading. 44, Malaj, may see that the facts which we are saying are fraudulent must have a causal connection. That's it.
Yes.
That is all that I wanted to highlight on this judgment. Malaj, may now come to the next judgment, which is of this honorable court, of a coordinate bench of this honorable court, Reshmi Metallics. The relevant paras, Malaj, may please note. I will supply it also, the index, in the course of the day. The relevant paras are 11, 16 to 17.
Yes.
23, 24, and 29 to 51. This is in the context, Malaj, of a 36(3) application. The court is considering a stay, an unconditional stay on the ground of fraud. The language that is used in 34(2)(b) is identical to the language that has been used in 36(3).
Yes.
Malaj, may please have a look at para 11 first. at page 21.
Right.
Well, this was a matter between the railways and one of the suppliers of the railways. The Honorable Court was looking into the fact that the very making of the conduct of the party was collusive. And in fact, the court went into the aspect of whether the court can look into the aspect of collusion at the stage of 36.3. And the court goes on to hold that it can, and rejects the point that look, it can only be a party inducing a fraud. Manoj, may please see at para 11. Just a few aspect of facts, then I'll straight away come to law. Para 11 at page 21. Observations. Manoj, have that?
Yes, yes.
Yeah. In the arbitral proceedings, the claimant has filed claims under 7 different heads for a total of 4,380 crores. And the respondent had submitted its counterclaim of 148 crores for the revenue loss incurred during the period from 2009 to 17. It is to be noted that the claims in the impugned arbitral award has been bifurcated into 2 clearly segregated compartments, wherein the first set of claims arise out of so-and-so agreement for the first and the second rakes, and the second set of claims are for those arising out of supplementary agreement dated so-and-so for the third and the fourth and the fifth rakes. Therefore, these claims are concerned only those of time periods when the rakes were under the zonal jurisdiction of so-and-so for the period between so-and-so for the first rakes between January to May of 2019, for the third rake, and between January so-and-so to for the fourth and the fifth rake. Maharaj, may now please straight away come to para 60 over the page. 23.
Yeah.
I have perused the arbitral award dated May 10, 2021 meticulously, and accordingly, I could prima facie observe glaring irregularities and palpable impropriety in the conduct of railways in defending their stance before the arbitral tribunal by way of their crystal clear reluctance in presentation of any evidence or witness, inadequate and cursory cross-examination of claimants' witnesses, and inexplicable failure to submit documentary evidence, among others. Similarly, I have undertaken an extensive study of the arbitral tribunal's order dated so-and-so, wherein corrections to the arbitral award were incorporated. The puzzling rationale put together by the arbitral tribunal in corrections has left me baffled, and I began to question myself as to whether the unfathomable reasoning provided therein could be justified by any acceptable standard of interpretation and analysis. Then, my lords, the Honorable Court goes into it. My lords, may please straight away come to, I'm not going into what are the irregularities, but he notes what exactly are the irregularities. And then, my lords, may please see at page 29. That's where the discussion on law starts, my lords. So if I can just give a snippet of the kind of irregularities that's found by the court, is that the claims are left unquestioned, my lords. No cross-examination is done. The documents which are in possession are not produced. So that is what the court goes into step by step. I'm not going into those facts. Those are not germane for us. But that's the kind of irregularity that the court finds in the conduct of the party. Then, my lords, will please see para 29 at page 29.
Yes.
The Honorable Court goes into the aspect of fraud. Oxford's dictionary defined fraud as so-and-so. From a legal standpoint, Black says reproduced. Then Chingarvai, I'm not going to read it all over again, my lords. Then, my lords, may please look at the next page at Venture Global and Tech Mahindra. This is a different Venture Global. The one that we read was 2000. This is a 2018 judgment.
Right.
While dealing with the question as to what constitutes fraud, the learned author said, what amounts to fraud has been settled by the decision of the House of Lords in Derry versus Peake, where Lord Herschel said fraud is proven when it is shown that a false representation has been made knowingly, without belief in its truth, or recklessly, careless whether it be true or false. The author has said that the courts of equity have from a very early period had jurisdiction to set aside awards on the ground of fraud, except where it is excluded by the statute. So also, if the award was obtained by fraud or concealment of material circumstances on the part of one of the parties so as to mislead the arbitrator, or if either party be guilty of fraudulent concealment of matters which he ought to have declared, or if he willfully mislead or deceive the arbitrator, such award may be set aside. The author said that if a man makes a representation in point of fact, whether by suppressing the truth or suggesting what is false, however innocent his motive may have been, he is equally responsible in civil proceedings as if he had, while committing these acts, done so with a view to injure others or to benefit himself. It matters not that there was no intention to cheat or injure the person to whom the statement was made. This rule of law is applicable not only between the two individuals entering into any contract, but is also applicable between an individual and a company and also between the two companies. The author said that this principle is also not limited to cases where an express and distinct representation by the words has been made, but it applies equally to cases where a man by his silence causes another to believe in the existence of a certain state of things or so conducts himself so as to induce the reasonable man to take the representation to be true and to believe that it was meant that he should act upon it, and the other accordingly acts upon it and so alters his previous position. The author said that where there is a duty or obligation to speak and the man in breach of that duty, obligation holds his tongue, does not speak and does not say the thing which he was bound to say. If that be done with the intention of inducing the other party to act upon the belief, the reason why he did not speak was because he had nothing to say, there is a fraud. Now, corruption. While corruption can be difficult to define, I turn to Oxford and Merriam-Webster's dictionary, which put corruption as dishonest or fraudulent conduct by those in power. Dishonest or illegal behavior, especially by powerful people. Furthermore, Roblin and Perkins and Boyce in criminal law defines corruption as the word corruption indicates impurity or debasement, and when found in criminal law, it means depravity or gross impropriety. Now, the observations which have been elaborated above indicate towards two separate situations of collusion and foul play, and to the mind of this court, prima facie seems to be a direct consequence of fraud and or corruption in the making of the award. Firstly, the arbitral proceedings, the absolutely appalling conduct of SER in defending claims upwards to 4,000 crores. Here, not only did the railways not produce any witness of its own, but also failed to present any documentary evidence to contradict the arguments put forth by the claimant. The ludicrous cross-examination of the claimant's witnesses screams of surreptitious connivance between the parties, wherein it had been already decided that the railways must abandon all its leverage in favor of the other side and superficially continue to fight an already lost battle under the aegis of incapable generals coupled with unguarded defenses. Secondly, the atrocious explanation given by the arbitral tribunal in justifying its order of correction has left me at loss of words. The aforesaid order made me wonder if the tribunal thinks so lowly of the executing court, where it may have hope that such corrections would be permitted a safe passage without any scrutiny whatsoever. Moving forward, the right of a party to seek recourse against an arbitral award on the grounds of fraud or corruption has been provided in 34(2)(b) of the Act, which provides for setting aside of an award which is in conflict with public policy of India. Explanation 1, the amendment. Now, in the amendment, over the page, just the bold portion, the address the issue of corrupt practices in securing the contracts. The intent was to address the issue of corrupt practices in securing contracts or arbitral awards. A need was felt to ensure that all stakeholder parties get an opportunity to seek unconditional stay of enforcement of arbitral awards where the underlying arbitration agreement or contract or making of the award is induced by fraud or corruption. Thus, I am of the view, if this court even suo motu upon prima facie observing that the making of an arbitral award has been induced or effected by fraud or corruption, can grant an unconditional stay of the arbitral award, which is in consonance with what the Honorable Supreme Court also says, Malad. Now, over the page, Malad, it must para 42. It must be noted that the Parliament in its wisdom has deemed it appropriate for this court to exercise discretion in grant of stay on an arbitral award when such an award is either induced or effected by fraud or corruption. The only prerequisite in exercise of such discretion is the court must be satisfied that the prima facie case is made out. On bare reading of the aforementioned provision, this court is of the view that the conduct of the parties during the arbitral proceedings qualifies as a consideration under the proviso to section 36(3) of the Act, as the same is not only indispensable in the making of the award, but also materially induces the making of the award. Therefore, to arrive at a finding that the making of an award is induced or affected by fraud or corruption, this court can look at the conduct of the parties during the arbitral proceedings. In the present case, with respect to the conduct of the
The
parties,
rest of the facts of the case, Mr. Shinde, we can skip over.
yes, Manoj. So 44, then Manoj may lastly look at para 53.
Yes.
The learned Advocate General relied upon several case laws to contend that an award is to be obtained by fraud if the party, now this is the point, if the party which has deliberately concealed the evidence has as a consequence of that concealment obtained an award in its favor. He added that the essence of fraud in the making of the arbitral award is that the evidence now being relied upon by the aggrieved party is such as could not have been obtained or produced during the arbitral proceedings, even with reasonable diligence, and was newly discovered post the arbitral proceedings. In the instant case, the learned Advocate General argued that evidence and documents now intended to be relied upon by the railways were at all material times within their control, possession and special knowledge, but the same was never presented by the railway before the tribunal. Therefore, this is not a situation where the award debtor is being made to suffer an award which was obtained through concealment or suppression by the award holder. Para 54 over the page, Malad. While I am in complete agreement that an award debtor should not be made to suffer an award obtained by way of fraudulent concealment of material evidence by award holder, I ask myself whether this is indicative of the only possibility of an arbitral award being obtained by deliberate concealment or suppression. With great humility to the eloquence of the learned Advocate General, I am of the contrary view that given that fraud has a very wide connotation in legal parlance, it is egregiously absurd to suggest that any award which may be fraudulently obtained is limited and restricted to the above instances cited by him in the preceding paragraph. The court cannot overlook fraud being perpetuated in making of the award by way of collusion between the parties. In any event, as at this juncture, this court is not coming into any conclusion on setting aside of an arbitral award. The case law cited by the learned Advocate General can be comprehensively considered by the court at the stage of adjudicating the Section 34 application. 56 and 57 are relevant, Malaj, because he doubts the intent of arbitration there. 56, arbitration was initially envisaged as means to reduce litigation and promote faster resolution of disputes, and over time, due to active involvement of the courts and cooperation of the parties alike, arbitration culture has been thriving in India. Now, as judges, we are expected to deal with each matter on its own merits, and judgments and are pronouncements on the merits of the case at hand rather than an occasion to make general comments and observations. However, in dealing with the present case, I have been plagued by a deep worry resulting from railways' conduct in the present matter, which I would like to put forward. Not to mince my words, the attitude of some of the parties, especially public sector undertaking companies, towards the arbitration process and utter disregard for it has made me doubt the future of the arbitration in India if it keeps going the present way. 57. Arbitration as an alternative dispute resolution mechanism holds great significance towards economic development, and arbitration proceedings must be regarded as sacred as a court proceeding. When the parties' conduct in front of an arbitration tribunal or the court must be the same. Rather than seeing arbitration as a protective umbrella that serves the parties from spending extra time, money, and efforts required in litigation, in many cases, it has now become a well-oiled tool to perpetuate fraud and or corruption in the hope that the courts might overlook it. When the parties involved themselves work towards diluting the essence behind the arbitration and defeat the very purpose for which it exists, it really brings forth doubts in the mind of this court with regard to the efficacy of the arbitration as an alternative dispute resolution mechanism. Even if only one party acts against the spirit of arbitration, its effect is not only limited to itself, but rather affects the sanctity and integrity of the entire arbitration culture. And therefore, when either of the parties disrespect the sanctities of the arbitration process and seek to hide under the cloak of the same to effectuate fraud and or corruption, the process works against the foundational principles of arbitration. And finally, Malaj, the Honorable Court grants a stay, an unconditional stay. The next is a similar judgment, Malaj. I won't read it. Malaj may just mark the paras. 11 to 19, 20 to 23, 25, 27. Another judgment by this Honorable Court on this aspect. On the fact, Malaj, the stay was not granted, but the principles are referred.
Right.
But I won't duplicate it, Malaj, because it's been stated what I wanted to say on that aspect.
Yes.
Now, Malaj, may please look at the fourth judgment at page 49, just one paragraph in that judgment. Page 49, I'm going to refer to para 11, Malaj. Starts at page 49, para 11 is at page 53.
Yes.
It is on, it's a Jharkhand High Court, Malaj, division bench. Para 50, page 53, para 11. The factual context is different, Manoj, but just this one paragraph is of perhaps some significance for us. First of all, clause 2 of subsection 2 of section 34 clearly lays down that an arbitral award may be set aside by the court if the court finds that the award is in conflict with public policy of India. In the explanation appended to clause 2, it has been amply clarified by means of a declaration that an award should be deemed to be in conflict with public policy of India if the making of the award was induced or affected by fraud or corruption, or the same was in violation of section 75 or 81. Shorn of all unnecessary details, it was suffice to say that bias or prejudice, if alleged against an arbitrator, can always be brought within the ambit and scope of the expression fraud or corruption. If a party facing an award passed under subsection 4 of 13 while taking recourse to the remedy of challenging the same under subsection 5 of 13, read with section 34 2b2 of the Act, alleges and establishes that the arbitrator was biased and prejudiced against him, the making of such an award undoubtedly can be vitiated on that ground if proved or established, and such being against the public policy of India, the award would be liable to be set aside. The making of an award induced or affected by fraud or corruption being a clear ground, and the bias and the prejudice of the arbitrator against the party challenging the award would squarely come within the aforesaid two expression, thus enabling the party to successfully challenge in court the making of the award and obtaining an order of having it set aside. The party therefore cannot be said to be without any remedy. So just to say, Malas, that bias would also be a sort of a species of fraud. Now, Malas, having said that, although Malas, I have not pleaded bias per se, nor have I established bias, but the factum of the award, the way Malas I have proceeded to show in the facts, there is perhaps there is clearly fraud or perhaps bias, Malas, either by both the members or a singular member, depending on, because beyond a particular point, I cannot, Malas, point out, and that's the test that I just wanted to highlight to this honorable court, that the test for fraud or bias is going to be a third bystander test. And that's the next judgment, Malas, which is at page 55. This is a Constitution Bench judgment, a recent Constitution Bench judgment, only on the point that what is the test of bias. Malas, please have a look at para 88 first. The concept of bias, Malas, actually starts at page 133, where Malas will see 82. But Malas, please, I'm not going to read all of them. From 82 to 87, there are judgments which the honorable court cites.
Right.
Then at page 8, para 88 at page 135, they sort of put everything together in the test. The principle governing the doctrine of bias is that a member of a judicial body with a predisposition in favor of or against any party to a dispute, or whose position in relation to the subject matter or a disputing party is such that a lack of impartiality would be assumed to exist, should not be a part of the tribunal composed to decide the dispute. This principle is applicable to authorities who have to act judicially in deciding rights and liabilities and bodies discharging quasi-judicial functions. A quasi-judicial authority empowered to decide a dispute between opposing parties must be one without bias towards one side or the other. A member of a tribunal which is called upon to try issues in judicial or quasi-judicial proceedings must act impartially, objectively, and without bias. Now, just the test of bias, Malas. The likelihood and the real likelihood of bias. I'm not reading 89 and 90, Malas. That's on the point of automatic disqualification. Malas, please have a look at straight away 92. The nemo judex rule may be applicable where a judge's conduct or circumstances give rise to an apprehension of bias. In such situations, the judge does not have a financial or cause-based interest in the outcome of the dispute, but provides benefit to a party by failing to be neutral and impartial. The determination of bias does not depend upon actual proof of bias, but whether there is a real possibility of bias based on the facts and circumstances. In R versus Sussex, the applicant was charged with the offense of dangerous driving, which involved a collision with another vehicle. The prosecution brought a case against the applicant before the magistrate's court. Simultaneously, the driver of the other vehicle also instituted civil proceedings against the applicant. The solicitor hired by the other driver in civil proceedings was also acting as magistrate's clerk in the criminal proceedings. At the conclusion of the evidence before the magistrate, the acting clerk retired with the judge to their chambers. The magistrate convicted the appellant without consulting the clerk. In appeal, the divisional court quashed the conviction. Learned Heward Chief Justice held that the clerk's involvement in the civil proceedings made him unfit in the circumstances to serve as a clerk to the magistrate in the criminal matter. Lord Heward Chief Justice observed that the question depended not upon what actually was done, but upon what might appear to be done, and the judicial proceedings will be vitiated if there is even a suspicion that there has been improper interference with the course of justice. Over the course of time, the English courts have preferred the test of real likelihood to determine bias. In so and so, Devlin not justice observed that real likelihood depends on the impression that the court gets from the circumstances in which the justices were sitting. However, in Metropolitan and so, Lord Denning expressed the test of real likelihood of bias as being whether a reasonable person would think it likely or probable that a judge or member of a tribunal was biased. Then, Malaj, the UK court, Malaj, may now please straight away come to the Indian approach at page 143. This is, I just wanted to give a precursor of how it started in common law, Malaj. Now and I don't want to read all of them, Malaj are already aware of it. At page 143, Indian approach to the bias test. At 103, Malaj. This court has consistently adopted the real likelihood test to determine the bias. In Manaklal versus so-and-so, Gajendra Gadkar Justice, as the learned Chief Justice was, observed that the test to determine bias is whether a litigant could reasonably apprehend that a bias attributable to a member of the tribunal might have operated against him in the final decision. Matthew Justice observed that the test of likelihood of bias is based on reasonable apprehension of a reasonable man fully cognizant of the facts. The learned judge further observed that the question of whether the real likelihood of bias exists is to be determined on the probabilities to be inferred from the objective circumstances by a court or based on impressions that might reasonably be left on the minds of the aggrieved party or the public at large. The legal development under the English law about the real danger of bias test was also accepted by this court. In Kumaon Mandal versus Vikas Nigam, this court observed that the real danger of bias is essentially based on deciding bias based on the facts and circumstances of the individual case. In MP Special Police Establishment Act, the Constitution Bench referred with approval to the Kumaon Mandal Vikas Nigam. Subsequently, the decision in PD Dinakaran traced the evolution of bias test under the Indian jurisprudence to state the following principles. To disqualify a person from adjudicating on the ground of interest in the subject matter of list, the test of real likelihood of bias is to be applied. In other words, one has to inquire as to whether there is real danger of bias on the part of the persons against whom such apprehension is expressed, in the sense that he might favor or disfavor a party. In each case, the court has to consider whether a fair-minded and informed person, having considered all the facts, would reasonably apprehend that the judge would not act impartially. To put it differently, the test would be whether a reasonably intelligent man, fully apprised of all the facts, would have a serious apprehension of bias. In Supreme Court Advocates Bar Association, Advocates on Record Association, Union of India, Justice Chalameshwar, writing for himself, and Justice Goyal summarized the following principle. If a judge has a financial interest in the outcome of a case, he is automatically disqualified. In cases where the interest of the judges in the case is other than financial, then disqualification is not automatic. But an inquiry is required whether the existence of such an interest disqualifies the judge, tested in the light of either on the principle of real danger or reasonable apprehension of bias. Pinochet case added a new category, that the judge is automatically disqualified from hearing a case when the judge is interested in a cause which is being promoted by any one of the parties to the case. Although there have been vacillations about the test in England, the Indian courts have been largely consistent in their approach by applying the test of real likelihood of bias or reasonable apprehension of bias. Recently, the court has used the real danger of bias test. However, the above discussion shows that there is no significant difference between the real danger of bias test and the real possibility of bias test if the question of bias is inferred from the perspective of a reasonable and a fair-minded person. This court has now they talk about judgments, but the test is culled out in para 107. And Malaj, page 110, para 110, they talk about bias in the context of the Arbitration Act. Para 113, Manoj, may please have a look at.
Yes.
The fundamental premise of arbitration is the impartial resolution of dispute between the parties according to arbitration agreement. Unlike a judge, an arbitrator is generally engaged in occupations and professions before, during, and after the arbitral proceedings. The arbitrator may also have had prior commercial and professional contact and relationship with either of the parties to the dispute. In such circumstances, arbitration laws evolved safeguards and mechanisms to ensure independence and impartiality. The independence of an arbitrator is generally considered with respect to relationship or links between the arbitrator and one of the parties, whether financial, professional, employment, or personal. The independence of an arbitrator can be deduced objectively because the dependence arises from the relationship between an arbitrator and one of the parties or somebody closely connected with
This
one of
is
the.
apparently on the 7th and 5th schedules.
That's right, Manoj. That's 12 and 13, so that's not relevant. But the
Right.
the concept of bias is what I wanted to bring to the notice of the court.
Understood. Yes.
That's right. Then
If-
Malaj, may please. Yes, yes. Then Malaj, may please come to a judgment that I have put. It's of a Singaporean court. It's a
Right.
Singapore, the Court of Appeal in the Republic of Singapore. I just wanted to highlight two aspects. Bias, my lords, have already seen. In the Singaporean judgment, the context was slightly different, Malaj. The arbitration award was being tested as being a substantial reproduction of an earlier award by the presiding arbitrator. So the question before the court was that whether substantial reproduction from other awards into this award violates any of the principles of either bias or equality of arbitrators.
Oh, that.
I'm so sorry, Manoj.
That one.
Yes, Manoj, 31-2. Yes, that exactly that one, Manoj. Exactly that one. Exactly that one.
Very well.
I don't want to get into
Need
the.
not-
Yes.
need-
So
Understood.
it is exactly that one, Malaj.
That copy paste and all.
Yes. Copy paste. It's in that factual context that it is based, but the concept of law, Malaj, that it provides, and I was actually very surprised to read the judgment with the kind of precision that they, in minimum words, the kind of precision that they have to convey what they want to, both in this judgment and the other judgments of the courts outside. But one of the aspects that they touch upon is the concept of equality of arbitrators, because one of the allegations was that the other two arbitrators didn't perhaps know.
Half a second. This
Yes,
is already there.
Oh, sorry, Madam.
Yes. Sorry. Yes.
Yes. So the argument there was that the other two arbitrators, Malaj, were not aware as to from where it is copied and how it is copied and what the
Yeah.
presiding arbitrator did, so on and so forth. There they touch on the aspect of equality of arbitrators and perhaps the arbitrators being involved in the making of the award. So there, only with that purpose, Malaj, may please note down the paras at 38, 39, 58, 60, and 83.
Now I've got the index also from your
I'm
Leonard Junior. So
I am obliged, Malaj. I'm so sorry why it
No,
should
no,
have
no,
been
no, no.
perhaps a glitch at my office, Malaj.
no issues. Yes. So this is on a different footing. I mean, rather more apt in your case. Equality between the arbitrators. That aspect.
Yes. Only that point is that what I wanted to stress. Bias, my lord, I've already seen, although they also extensively go into bias.
Yes.
In fact, they go on to say to the extent that bias really is violation of principles of natural justice.
Yes.
And they evolve the law right from what is a principle of natural justice and so on and so forth.
Because it hits at the root of the integrity of the process.
Absolutely, Malaj.
And
Absolutely.
party autonomy automatically gets.
Yes, Malaj, yes. So, Malaj, para 38, Malaj, may just see at page number. Sorry. 224. This is on the aspect of bias, Malaj. I'm just going to read two paragraphs and then shift to that other part. At page 224, more commonly, allegations of apparent bias are made against decision makers whose conduct of decision-making process gives rise to a reasonable suspicion or apprehension that he or she may have prejudged the dispute at hand. In each case, the allegation of prejudgment amounting to apparent bias must be grounded in the objective facts disclosed by the material in evidence. It is well established that this determination of apparent bias is not to be taken from the point of view of reviewing court, concluding that there was a real danger that the decision maker was in fact biased or had a closed mind. Rather, the question is whether a fair-minded and informed observer of public would, having considered all the facts and circumstances of the case, reasonably suspect or apprehend that the decision maker had reached a final and conclusive decision or might be predisposed to a given view before being made.
Actually, I don't take judgments home. I mean, take matters home.
Okay.
Precisely due to this reason, because it hits at the adversarial process. If I take a matter home and
Yes,
they
Malad.
come with a prepared mind,
Yes,
have a predisposition. So that's the established common practice in the Supreme Court and many high courts and many people. I mean, I don't have any objection if anybody has that practice to cut short the matter. But why should I? I mean, I'll have a predisposition, and it's a third argument which is already there in my mind. So therefore, I never take it due to that reason only, because I shouldn't have a predisposition before you argue.
absolutely,
That
Malad.
should be that is a basic premise of I mean judicial integrity. I not taking home. I mean predisposition.
Right, 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 Malad.
So
Right, right.
therefore, I completely understand and agree.
I am actually very pleasantly surprised, Malad, that this honorable court does not
No,
take
I deliberately do not, because if I can't
because
grasp
then,
the matter in first 5 minutes, Mr. Chindra, I
my
should
lord,
retire. I should retire.
my lord, my lords. No, no, no. It's not about. It's about.
Yes. So
That's not a reflection
38
on
is
Malad.
all on that. So I completely
Yes.
identify and understand. Yes.
Yes, yes. Well, so then just have a look at the last 58, 60, and 83, because that's where the equality aspect was defined.
Yes. Yes.
Malaj may have a look at page 232. At para 56 is where the expectation of equality starts.
Yes.
I am reading over the page. 58.
58 is.
Yes. Another important facet of principle of equality is the expectation of equality between the arbitrators, at least when it comes to consideration of the material upon which tribunal will make its decision. As observed in Singapore International Arbitration so and so, the requirement of equal treatment must be observed by the parties and the tribunal alike. Now, Malad, may please see 60. In our judgment, it follows from this that where an arbitrator is not equally placed with his co-arbitrators, it may be said that the other arbitrators have not had an equal, fair, and independent opportunity to discharge their adjudicative function. And this may be found to have undermined the core expectation of the parties when they choose to resolve their disputes by arbitration. To be clear, this does not mean that each arbitrator must have the same experience or hail from the same background. It is entirely within the parties' discretion to choose an arbitrator according to their own criteria. The point rather is that each arbitrator should be equally placed to have same access to the details of the dispute at hand and of the material on the basis of which they are to resolve it. For this reason, in a case where only one arbitrator has recourse to extraneous material, this is really Malaj in the facts of that case.
Yes. Yes.
So the principle I've laid down, and at page 8 and at para 83.
Yes. Right.
It starts with the 244.
Yes.
It
Yes.
starts with unequal position of the arbitrators. We also consider that expectation of equality as between the arbitrators was compromised. While, as we have noted, there is no evidence as to what actually transpired between the members of the tribunal, it is known that the two co-arbitrators in this case were not privy to the parallel arbitrations. They would thus have had no direct access to any material or knowledge derived from these proceedings, but which appeared to have significantly influenced the outcome of the present arbitration. The integrity of the arbitration was therefore further compromised as a result. In sum, we are satisfied that the award was correctly set aside for being made in the breach of rules of natural justice. So it's only on the aspect of equal participation of the arbitrators, Malaj, which is perhaps also codified in our law in 31(2).
Yes.
Then, Malaj, yes, then I have added one aspect, Malaj, which touches upon one of the concepts in the Sale of Goods Act, that an express warranty will outwit an implied warranty, if there is any. If an express warranty is there, which is contrary to any implied warranty, it is the express warranty which will prevail. This is a very old judgment, Malaj, of Dickinson versus Zizinia. It starts at page 248. I'm just going to read two. So there are no Malaj, paragraphs here, but just Malaj may have a look at the internal page 241, which is at 251. 251 of the compilation and 241. This was a case, Malaj, where a corn was to be supplied.
241 it should be.
Internal page 241, the page is 251.
Right.
Yes,
Right.
yes. So This was a case, Manoj, that where corn was to be supplied, and there was an express warranty as about the quality of the corn, which was to be transported from one port to the other.
Why is this
The-
relevant in your case, Mr. Chandra?
Yes, Manoj, it's relevant because clause 14 in our case,
Yes.
clause 14 of the guarantee clause, gives an express warranty of
Ah.
either 14 months or either 18 months or 24 months
Right.
from the commissioning or from the date of supply.
Hmm.
Now, any argument to say that dehors of that guarantee,
Hmm.
the product has to be of marketable quality even beyond that period, is something that is not permitted by law.
Understood.
That's the only argument, Manoj, there.
Right. Yes.
And Manoj, may please have a look at page 241.
Hmm.
Yes, internal page 241. Manoj, may now please see from the top of the page.
Hmm.
It's the font is a little smaller, Manoj.
No
I
difficulty.
couldn't find a better copy.
No, it's all right. Yes.
Yes. We would be doing greatest injustice if, with reference to the time and manner of this contract, we were to imply a warranty which the party never contemplated. Where there is an express warranty, the court will not extend it by implication. The rule as to construction of written instruments is laid down very clearly in the case of Lady Hively's charity. Suppose this contract had been altogether silent as to the condition of the corn. The argument on the other side must be that the law absolutely implies a fitness of the particular voyage or for a foreign voyage. Assuming that to be so, if you find that the contract contains the limited condition of warranty that the cargo is in good and merchantable state at the time of shipment, the expression of the one condition of necessity exclude the implication of the other and more extended warranty. The learned judge, therefore, was clearly wrong in leaving it to the jury to say whether the corn was in good and merchantable condition for a foreign voyage. I am of the opinion that this rule should be made absolute. The question depends upon the true construction of the contract set out in the declaration and whether we look at it merely as it is stated there or with reference to state of things within the knowledge of the parties at the time of the contract was entered into. I think it has not that meaning which Lord Turo assumed that it had in leaving the case to the jury. One question which his lordship left to them was whether the corn at the time of the shipment was in good and merchantable condition for a foreign voyage. He also left another question to them in the terms of the second issue, whether the corn was in good and merchantable condition generally for the sale at the port of the shipment. Whatever be the legal effect of these latter words, they are the very words of the contract. The jury did not think proper to find anything with respect to that question. But they did come to a conclusion upon the first question. They said that the corn was not in good and merchantable condition for a foreign voyage or for the voyage in question. I am not quite certain which, but that is immaterial, for I am of the opinion that the true construction of the contract is that the defendants warranted the corn to be of good and merchantable quality only. Thus, this is the only conclusion I can come to, whether I consider the circumstances under which the contract was made or look at the terms of the contract alone. The declaration states that the plaintiff agreed to buy the defendants the cargo of Indian corn then shipped at Orfano on board the Ottoman. And it shows that there was an intention on the part of the purchaser to forward the corn by that vessel to a port in England or Ireland. Then come two express stipulation as to the quality and condition of corn. The first is not that it shall be good or marketable, but that it was equal to average of the shipments of Salonika that season. And further, the defendants add that the said Indian corn has been shipped to wit on board the Ottoman in good and merchantable condition. The first is a stipulation as to the quality of corn. The second as to its condition at the time of shipment. Now, nobody denies these words would be sensible words if they had no reference to any foreign voyage or to any purpose for which the corn was destined by the purchaser. It is insisted that on the part of the plaintiff that though the words of the contract are capable of consideration, I have put upon them, yet that as it appears upon the face of the contract, that the parties contemplated that the corn was to be sent to Cork or to a port in England, that is to have the effect of changing the general stipulation that the corn is in a good and merchantable condition when shipped into a special condition or warranty that it is good and merchantable for the purpose in view. I think that is not the proper construction of the contract, and we must not depart from the ordinary in the proper construction of the contract that the parties have used, where that construction leads to no uncertainty or manifest inconvenience. Looking at the language of this contract, I think the proper mode of construing it is to hold it to be quite independent of the voyage on which the corn was to be shipped. For anything that appears upon the finding of the jury, the corn may have been in a perfectly good and marketable condition and yet not fit for the voyage in question. It may be that no condition of Indian corn or the average of the shipments in season of 1847 would enable it to reach Cork, Liverpool, or London in good and marketable condition. The plaintiff has taken that risk upon himself. It is very improbable that the parties should have entertained any other intention than that which it appears to me to be simple and obvious one. But if we look at the evidence upon the subject, which I think we may do for the purpose of ascertaining whether it is that the parties were contracting about, it seems to me to be a thing very unlikely that the sellers would undertake with respect to this particular commodity to warrant that it should be in good and marketable condition at the end of the voyage. Several cases as to implied warranties have been referred to. To these, there are two answers. First, that where there is a total silence as to warranty in the contract and all is left to implication, the law employs no warranty if the subject parties have expressed the warranty they intended to be bound by. In giving the second answer to those cases, I assume that the construction which I put upon this contract is the true one. We should not by inference insert a contract implied provisions with respect to a subject which the contract has expressly provided for. If a man sells a horse and warrant it to be sound, the vendor knowing at the time that the purchaser wants it for the purpose of carrying a lady, and the horse though sound proves to be unfit for that particular purpose, this would be no breach of the warranty. So with respect to any other kind of warranty, the maxim expressum facit caesar tacitum applies to such cases. If this were not so, it would be necessary for the parties to every agreement to provide in terms that they are to be understood not to be bound by anything which is not expressly set down, which would be manifestly inconvenient. I therefore think that this contract did not receive the proper construction at the trial, and therefore that the cause must go down again. So, anything that is expressly provided will prevail as compared to any other implied warranty that they would want to put into. The last portion, in the index is just the definition of fraud and corruption. I've just placed it for the convenience of the court. I'm not going to read it. These are derived from two established books, Black's Law Dictionary for both corruption and fraud, and also of P. Ramanatha Iyer's Advanced Law Lexicon. Right. Now, just coming back to the earlier compilation. This compilation is complete,
Yes.
To the earlier compilation, just one last section is left, which is also something very quickly we can finish. So I had completed in the main, in the index, we have completed until serial number 19.
Yes.
Yeah, only one aspect is left. That's the business efficacy interpretation. And that I am only putting because to place that interpretation on the clause, on the guarantee clause, that there was never, that there could be no commissioning from the time. Every time that the machine breaks, there could be no commissioning and it will be deemed to be recommissioned from that time. Is something that I'm wanting to be, and that's the reason why I rely on the judgment also on the point that anything where the interpretation is also perverse, the court can interfere. And any interpretation of a contract must be forwarding the business efficacy of the contract and not just to saddle the other party. Malaj, please have a look at 517. That's where the judgment starts. And the relevant portion, Malaj, is 34 to 49. Malaj, I won't read the entire portion, just first 3 or 4 paragraphs, which would put it in perspective. That's all. Malaj, have a look at para 34 at page 533.
Yes.
To begin with, we refer to the judgment of the Court of Appeals. 33, just an introduction. The contours of the controversy show that we are really concerned with the interpretation of commercial contract inter se the parties. Before analyzing the relevant clauses of the contract, including definition clause and formula, we consider it appropriate to set forth certain judicial pronouncement relevant for determination of the issue. To begin with, we refer to the judgment of the Court of Appeal in Morocco Bound Law Just. In the Morocco Bowen Lord Justice dealt with implied warranty on the part of the owners of the jetty in respect of a contract made for use of the jetty to a ship for discharge of its cargo. The name of the ship was the Morocco. It was observed as under. Now, an implied warranty, or as it is called a covenant in law, as distinguished from an express warranty or an express warranty, really is in all cases founded on the presumed intention of the parties and upon reason. The implication which the law draws from what must obviously have been the intention of the parties, the law draws with the object of giving efficacy to the transaction and preventing such failure of consideration as cannot have been within the contemplation of either side. And I believe that if one were to take all the cases, and there are many of implied warranties or covenants in law, it will be found that in all of them, the law is raising an implication from the presumed intention of the parties with the object of giving to the transaction such efficacy as both parties must have intended that at all events it should have. In business transaction such as this, what the law desires to effect by the implication is to give such business efficacy to the transaction as must have been intended at all events by both the parties, who are businessmen, not to impose on one side all the perils of the transaction or to emancipate one side from all chances of failure, but to make each party promise in law as much at all events as it must have been in contemplation of both parties that he should be responsible for in respect of those perils or chances. The significant issue was the principle of business efficacy to the transaction which are intended at all events by the parties who are businessmen. The aforesaid was once again relied upon in Sherlaw versus Southern Foundries. I recognize that the rights or duty of a court to find the existence of an implied term or implied terms in a written contract is a matter to be exercised with care, and a court is too often invited to do so upon vague and uncertain grounds. Too often, also, such an invitation is backed by the citation of a sentence or two from the judgment of Bowen Lord Justice in the Morocco. They are sentences from an extempore judgment, as sound and sensible as all utterances of that great judge. But I fancy that he would have been rather surprised if he could have foreseen that these general remarks of his would come to be a favorite citation of a supported principle of law. And I even think that he might sympathize with the occasional impatience of his successor when the Morocco is so often flushed for them in that guise. For my part, I think there is a test that may be at least as useful as such generalities. If I may quote from an essay which I wrote some years ago, prima facie, which in any contract is led to be implied and need not be expressed is something so obvious that it goes without saying. So that if while parties are making their bargain, an officious bystander were to suggest some express provision for it in their agreement, they would testily suppress him with a common, oh, of course. At least it is true, I think, that if a term were never implied by a judge, unless it could pass the test, he could not be held to be wrong. The aforesaid that extended the word of caution while applying the Morocco test. In so and so, these principles, however, have been clearly established. The first thing is to see what the parties have expressed in the contract. And then an implied term is not to be added because the court thinks it would have been reasonable to have inserted it in the contract. A term can only be implied if it is necessary in the business sense to give efficacy to the contract. That is, if it is such a term that it can confidently be said that if at that time the contract was being negotiated, someone had said to the parties, what will happen in such a case? They would have replied, of course, so and so will happen. We did not trouble to say that. It is too clear. Unless the court comes to some of such conclusion as that it ought not to imply a term which the parties themselves have not expressed. Is that a necessary implication? If this matter has been mooted at the time when the contract was being negotiated, I expect the parties would at once have disagreed as to what the position was. Unless we are satisfied that it is an implication which must necessarily have been in the minds of both the parties, we cannot imply a term which they have not expressed, especially when I see that they have thought sufficiently about the matter to express two conditions on which the agreement is to be determined. First, the obvious one on the death of the agent, and the secondly, by 6 months' notice, and so on and so forth. So this is what they continue with. I don't want to read all of them, but the point being that an implied cannot be inconsistent with the express, and the implied also would be in tune with the concept of business efficacy to give the effect to the contract and not to just saddle me or the other party. Then, on the same point, there is another judgment of 2016 which is at 556. This is the last judgment on the point, Malad. I'm not reading all the paras, Malad, so I have marked them as far as the earlier one is concerned. Now, Bharat Aluminium.
Yes.
Malad may see para 6, 10, and 11. Six is Malad's factual. Malad may please straight away come to para 10.
Yes. 10.
Page 561. In the matter of interpretation, the court has to make different approaches depending upon the instrument falling for interpretation. Legislative drafting is made by expert and is subject to scrutiny at different stages before it takes final shape of an act, rule, or regulation. There is another category of drafting by lawmen or document writers who are professionally qualified and experienced in the field of like drafting deed treatises and settlements in court. And then there is a third category of documents made by laymen who have no knowledge of law and expertise in the field. The legal quality of perfection of the document is comparatively low in the third category, high in the second, and higher in the first. No doubt, in the process of interpretation in the first category, the courts do make an attempt to gather the purpose of the legislation in its context and text. In the second category also, the text as well as the purpose is certainly important. And in the third category of documents like wills, it is simply intention alone of the executor that is relevant. In the case before us, being a contract executed between the two parties, the court cannot adopt an approach for interpretation of a statute. The terms of a contract will have to be understood in the way the parties wanted and intended them to be. In that context, particularly in agreement of arbitration, where parties' autonomy is the ground now, how the parties worked out the agreement is one of the indicators to decipher the intention, apart from the plain or grammatical meaning of the expression and the use of the expression at the proper places in the agreement. Contextually, it may be noted that in the present case, the respondent had invoked the provision of English law for the purpose of initiation of unsettled dispute. It has hence, while interpreting an agreement, to be kept in mind that the parties intended to avoid impracticable and inconvenient processes and procedures in working out the agreement. Water Justice made the similar observation in so and so. It is not a permissible method of construction to propound a generally accepted principle and then seek to force upon the provision of the contract into the straitjacket of that principle. On the other hand, modern principles of construction require the court to have regard to the commercial background, the context of the contract, and the circumstances of the parties, and to consider whether against that background and in that context, to give words a particular restricted meaning would lead to an apparently unreasonable or unfair result. So, Maharaj, business efficacy married with the context and married with the condition of the parties. That is what Malaj will have to keep in mind at the time of interpretation if we come to that point, Malaj. So, Malaj, having said that, we have now concluded our facts as well as law, subject to, of course, Malaj, if there are any clarifications from the bench or if there is any point in rebuttal from the other side at that point in time, we would just seek liberty of the Honorable Court to furnish anything further in rejoinder.
Thank you. Thank you, Mr.
I'm so obliged, Malat. I'm so obliged for the patient hearing, and I'm so glad
Thank
that I had an opportunity to argue before this honorable court.
No. Same here. Thank you.
I'm obliged, Malat.
I'm led by Mr. Bagh, who's appearing on.
Yes, Mr. Bagh is there.
May it please, Your Lordship.
Yes.
Milord, I am led in the matter by Mr. S.N. Mukherjee. So, Milord, may I only pray any suitable date to come back and we'll start our submissions.
Next Wednesday then? Next Friday, sorry.
Next Friday, Milord, we will come back.
Good.
Deeply pleased.
Heard learned counsel for the petitioner, who's on the prayer of learned counsel for the respondents, comma, let the matter stand adjourned till December 12, 2025 for further hearing.
I'm very deeply pleased, Milord.
Thank you.
I'm obliged, Malat.
Yes.
My lords, I appear on behalf of the petitioners. On the last occasion, if you, my lords, would recollect,
You had completed, your side has completed.
the respondents had made a reply. They had given the submissions, and Mr.
They were
Mukherjee was rejoining. He was giving submissions in rejoinder. My lords, if the matter could be passed over, he's just on.
Yes, I'll take that break now then.
All right. Very well, my lords. Grateful.
রিপিটিশনটা ছিল আর কোনটা ছিল জিএ
G1.
My lord, if your lordship just keeps, my lord, the writ petition and my lord, the
Right.
GA1, my lord.
Victor, the. Oh, sorry. Yes, both of them.
Yes. Now, my lord, on the last occasion, I dealt with, my lord, the point, my lord, that the GA is not maintainable. My lord, it is beyond the scope of the writ petition. That was, my lord, the point, my lord, which had been raised by my learned friend.
Yes.
And, my lord, my learned friend had relied on, my lord, two decisions, my lord, on this aspect of the matter. My lord, none of which I say, my lord, are applicable. Now, my lord, why did I say so? I had drawn your lordship's attention, my lord.
Judgment gulo ki side kuch dao.
That's the other side's judgments, my
Yes,
lord.
yes. Duty dao. Yes.
Now, my lord, the first point I raise, my lord, is, my lord, I had shown your lordships, my lord, the pleadings, my lord, in, my lord, the writ petition itself. My lord, one case was, my lord, of harassment. My lord, that continuously giving me notices, my lord, after, my lord, having said nothing is due from me. And, my lord, the SEBI clean chit as well, nothing is due from me. Both were, my lord, mentioned, my lord, in the writ petition. Second, my lord, specific case in the writ petition was we don't even know why this inspection is being taken, because after 2004, everything is over. And third thing we had stated in the writ petition was that, my lord, they said they'd return to us our security money if we withdrew the cases which we had filed earlier, saying they are wrongfully holding on to security money, not giving us interest on it, etc. Now, my lord, we had withdrawn, my lord, those cases. And in spite of that, my lord, they had not released. This was the subject matter. Then we filed a supplementary affidavit saying, in any event, the security money which you are keeping with you at present is in excess of the SEBI circular. My lord, I had shown the supplementary affidavit on the last occasion to the writ petition. Now, my lord, so, my lord, all this was covered, my lord, in the writ petition itself. My lord, page, my lord, 8, annexure P28, my lord, supplementary affidavit. This was, my lord, 4 lakhs only needed to be kept with them, nothing more. And, my lord, that was, my lord, my relief, my lord, which I had, my lord, prayed for, my lord, in the writ petition. Then, my lord, the day I, my lord, moved, they said it's not being released because there's an investigation. And, my lord, the order said, subject to result of investigation, you release. We went up on appeal, my lord, in that. And the appellate court order, my lord, I've drawn your lordship's attention to, my lord, page 145 to 148 of, my lord, GA1. And, my lord, kindly come again, my lord, to the operative portion, page 148. Volume 2, my lord, of
Yes.
GA1. My lord, kindly come to, my lord, page 148, last 10 lines. Hence, the plea of the appellant are bound by their own earlier stand, it should be, needs to be examined. Therefore, we set aside the order under challenge and request the learned single judge to decide the issue afresh. Meanwhile, 45 days period fixed by the learned single judge to take final decision has expired. Therefore, the final decision, if any, taken meanwhile, can also be placed, kindly note this, challenge before the learned single judge, and then such a final decision will be subject to the final outcome of the petition. The appeal is accordingly disposed of. So, my lord, it's very much now, my lord, the subject matter of the petition by virtue of orders of the division bench. In any event, my lord, I had submitted, my lord, on the basis of the averments made in the petition, the writ petition itself, and, my lord, the very fact that today, my lord, they treat this order, which is challenged in GA1, as a defense to, my lord, the relief, my lord, which is being claimed in the writ petition, my lord. It, my lord, no longer lies, my lord, in their mouth, if I may say so, to say, my lord, this is beyond the scope of the writ. Because my prayer, my lord, is being resisted on the basis of this, my lord, order. So, my lord, this is as far as, my lord, one of the preliminary objections is concerned. Second, my lord, is, what are you talking about breach of principles of natural justice? You were always aware that there was now an investigation pending against you. You were aware of the charges which had been made against you. And now that you have been found guilty of some of them, you cannot raise any complaint. There is no prejudice element, my lord, to my lord not being informed. Now, my lord, kindly take the list of dates once, my lord. There is my list of dates. Oh, sorry. Now, my lord, kindly come to my lord, the list of dates which I had handed up, my lord.
Yes.
My lord, item 5. To my lord, item 25. My lord, is the communications which were exchanged between 2002 and 2004. This is, my lord, very important. In none of the communications, my lord, is there a charge that I have, my lord, violated, my lord, any, my lord, SEBI circular or SEBI guideline. And second, my lord, in none of them is there a charge, my lord, that I have violated, my lord, any of Calcutta Stock Exchange, my lord, guidelines, rules, or regulations. And by virtue of that, my lord, I am, my lord, liable to a penalty, or, my lord, I am, my lord, liable to, my lord, refund, my lord, of, my lord, liable to a liability, if I may put it this way, a liability of 2.11 crores. And, my lord, a show cause is being given to me. Now, my lord, I had cited one case, my lord, before your lordships, which, my lord, I find, my lord, has not been dealt with. My lord, that is 2014, 9 Supreme Court cases, 105. Where, my lord, the test is, my lord, that, my lord, before any kind of penal action is taken, and here penal action also has been taken, my lord, I have to be informed about, my lord, the charges against me. My lord, I must be given, my lord, all documents, my lord, which are relied on by, my lord, the person charging me. My lord, two, my lord, charging me and saying you're liable. And, my lord, third, my lord, I have to be also informed as to what kind of a liability is being sought to be imposed on me, as well as the penalty.
Mr. Rai probably tried to distinguish by saying that that was a blacklisting in a tender process where he could not know
My lord,
what were the
my lord, with the greatest of respect, this
statutory
is
steps and
correct,
regulations.
correct. Now, my lord, here, in fact, I'll show your lordships, my lord, even under the guidelines, my lord, I'm required to be heard. Even under the guidelines. But, my lord, I'll come to that, my lord. But most importantly, give those SEBI letter and the CAC letter, no dues. My lord, kindly take, my lord, page 135, my lord, of GA, my lord, 1, volume 2, my lord.
Yes.
My lord, this is SEBI on, my lord, 27 November 2003. An inspection of your books for the period from April 2000 to August 2002 was conducted by SEBI during the year 2002. A copy of the inspection report was furnished to you, and we have received your reply via your letter dated January 22. The inspection has brought out certain irregularities in your operations, which are enumerated in the annexure. Now, my lord, kindly have a look at the annexure once, my lord. Page 136. Next page. My lord, one is contract notes.
Yes.
They are not issued in prescribed time. Then, my lord, non-collection of margin from clients. Then, my lord, exchange-wise bank accounts of inadequacy in maintenance of clients' database, non-payment of SEBI fees, publishing advertisement in print media. These were, my lord, the allegations. You are hereby advised I'm sorry, my lord,
Yes,
page
sir.
135.
Yes, bold.
To rectify the irregularities and warned not to repeat the same in future, and then. So, my lord, whatever, my lord, irregularities during the period, my lord, SEBI found were these. Now, my lord, kindly have a look at, my lord, in my writ petition, my lord, the letter of, my lord, Calcutta Stock Exchange, 11th October 2007. Now, this is, my lord, as of 11th October 2007. And, my lord, the transactions related to 2001. My lord, kindly take the writ petition, page 79. My lord, not the GA1, the writ petition.
Yes.
And, my lord, kindly note, my lord, from the list of dates, whatever inspection, queries, etc., all happened, my lord, between 2002 to 2004. My lord, that's the list of dates which I had given your lordship, my lord.
Yes.
If I'm not mistaken, my lord, those are the dates. Yes, my lord. 9th May 2002 to, my lord, 2004. Now, my lord, this is after that, 2007. Please refer to your letter dated 1st October 2007 on the subject cited above. In this connection, we would like to inform you that as per, kindly note this, records of the exchange, Dalmia Securities and SEBI registration is an inactive member of the exchange and it has no dues towards the exchange as on date. However, this should not be construed as a guarantee for any liabilities. Now, the next words are operative. My lord, very important. That may arise in future course of business in respect of the company. My lord, having given this letter, my lord, I would have thought, my lord, this was, my lord, the end of the matter. And there's no explanation, my lord, for this. Your lordship put a query also. Looking at this letter, you yourself have said, no, future case can also mean further investigation is nothing. Because investigation, according to them, my lord, was over by 2004. Now, my lord, it doesn't end there. Now, my lord, kindly take another aspect of the matter. My lord, kindly have a look at, my lord, the order 155 GA1 volume 2. Operative portion দাদা আছে। My lord, kindly come straight away, my lord, to the operative portion. On the face of it, I want to show your lordship. (168), my lord.
Yes.
Kindly see, my lord, there are 3 directions given here. Kindly come to the third. Penalty of ₹6 crores in line with the decision of the disciplinary action subcommittee at its meeting held on 24th May 2008. Now, there are 3 points. We were never given notice, my lord, of, my lord, the fact that we were being subjected to a proceeding before, my lord, the disciplinary action subcommittee, which could result in a penalty. Number 1. Number 2, my lord, disciplinary action subcommittee did not give us notice of hearing, my lord, in any matter. Third, my lord, even today, we don't have this decision. And so, my lord, it brings us back to, my lord, another, my lord, classical case that, my lord, they have relied on a decision which has not even been furnished to us. And what they claim to be a show cause, my lord, also doesn't have this. That is, my lord, the letter of 4th of March 2004. My lord, when, my lord, they have shown, my lord, that the show cause doesn't satisfy the ingredients. My lord, I could cite umpteen cases, the excise cases, customs cases, my lord, disciplinary, my lord, proceeding cases, blacklisting cases, because these all have civil consequences. Now, my lord, this document, which is relied on for, my lord, a 6 lakh penalty, my lord, is not even relied on, my lord, on the letter, my lord, which they describe as a show cause. My lord, once they realize, my lord, that it doesn't fulfill show cause, is the argument, oh, you knew what was happening. Oh, you knew what was happening, which is repeated, my lord, ad nauseum. And your lordship, kindly examine, my lord, the letters. None of them show that I'm subjected to, my lord, any proceedings which can result in an imposition of liability or penalty.
Now, another argument has been made that prejudice test. So apparently, Mr. I had insinuated that so they repeatedly told you to give the documents. You said I don't have the documents.
No, I gave the documents first time round,
Said that
and then I
already
said I've already given.
I've already given.
Yes,
So what else could you do if
correct.
you were given a hearing?
Yes.
No, that was his. That what else could you do if a hearing was given? I mean, no.
But those documents have to be considered. I've given a representation. None of my contentions find place in the order. Not one.
So they say that they, on the basis of the documents you have given or whatever was there or not there, they have taken a decision.
Yes, and I've shown your lordship, my lord, that synchronized trading by itself is not illegal.
Yes. So
My lord, I am not going into any disputed question of fact.
no.
I am saying all contract notes were there. Second, I'm saying there are no off-market transactions. Third, I'm saying you're saying yes, there's a on a particular date which they opened up, my lord, for trading by Dow Jones. When, my lord, Dow Jones, my lord, when, my lord, the trading happened. So, my lord, they have to show, my lord, this is a very, my lord, very hard test to fulfill. My lord, assume they are right, that, my lord, we would be trading, quoting, everything at the same time. But they have to show, my lord, that I knew when I traded.
That insider information angle was not established.
No, and they knew that there would be a loss. We ought to have known that. And therefore, there would be, my lord, a payout from the settlement guarantee fund. Well, my lord, I'm sure if the price had gone up, my lord, there'd be no case against me.
Obviously, yes.
My lord, they have to show I knew that. That, my lord, after, my lord, Dow Jones, my lord, may fail to make payment, as it ought to have as a broker, my lord, acting for the client, my lord, on the exchange. And, my lord, settlement guarantee fund payment had to be made. They could have stopped it also if they had doubts. It was all happening on their platform. They didn't stop it. Now, my lord, they ought to have known, my lord, I ought to have known that, my lord, a few months, few days, whatever down the line, my lord, when the settlement guarantee fund people, my lord, sold the shares, my lord, that they would make a loss. There's nothing.
Yes.
Now, my lord, the next is, my lord, the, my lord, constitution of the committee. Regulation 23. My lord, the regulation requires the presence of a managing director, shareholder director, and public interest director. My lord, admittedly, there was no shareholder director. My lord, at page 173, or managing director, I had shown, my lord, page 173. My lord, 173, my lord, the three individuals mentioned there who signed the order are all public interest directors. And, my lord, most important, my lord, on 27th May 2022, after I filed the GA, a shareholder director was appointed. My lord, that's at page 43 of the affidavit in reply. My lord, page 43 of affidavit in reply. GA. देखिए चिला मांगेशो.
Yes.
My lord, this will also find place in the note, my lord, but because my lord 23 was when I was last heard, my lord, my lord, this I'm taking advantage, my lord, of the reply to my lord, just quickly give your lordships, my lord. We have to be fair to your lordships, my lord. We forget, my lord, your lordships is human at the end of the day, your lordships, my lord. All judges, my lord, are human, my lord. So, my lord.
Right.
Then, my lord. Yes, now the most important, my lord. Their specific stand is that this March 2004 letter is the show cause. Show that stand. Millard, in the order itself, page 155. Millard, clause 1, 155.
Yes.
Agenda note relating to hearing given by the board, so and so, so and so, so and so, dated issued. B, show cause letter dated 4th March 2004. So they relied on it as a show cause. Lordship has that B, Millard. Item B in first paragraph.
Yes. Right.
This is their case. Having issued a show cause, now this can't say, oh, there was no show cause, you knew everything. There was a show cause. And my lord, that show cause itself also does not satisfy, my lord, the test. But my lord, kindly have a look at what my lord is relied on in the order. C, my lord. Kindly see C.
What is the page number of that show cause notice?
My lord, page 174. My lord, it's all in my list of dates. My lord, your lordship will get all the dates there.
Right.
My lord, fortunately, my lord, there was no complaint that one document is missing or anything from the list of dates. They're all there.
Yes. Now remember. Yes.
And your lordship will find, my lord, that, my lord, page 174, subject matter is inspection of your firm's books of accounts. This is supposed to be a show cause. And we gave a reply that is also mentioned. Now, my lord, kindly come to my lord, C. They rely on an inspection report. Now, my lord, that's not even seen the light of day today. My learned friend can't wish it away by saying, oh, the order reflects the inspection report. My lord, without having the inspection report, how is that statement, my lord, going to be, my lord, tested? They relied on an inspection report. And my lord, kindly note 156.
Yes.
My lord, third last paragraph, last sentence. This is the order. The order says inspection report became the basis on which a show cause notice was issued. And show cause doesn't even mention inspection report. My lord, every page of the order, my lord, has a reference to this inspection report. Now, my lord.
Yes.
Apart from this, kindly take, my lord, the affidavit in opposition, my lord, to, my lord, the GA. My lord, paragraph, my lord, 18 at pages 26 and 27.
Yes.
My lord, kindly see the para 18. My lord, now, my lord, very important. My lord, last two lines of page 26. In this regard, it would also be pertinent to mention that the documents relied upon by the respondent number 1 could have been made available to the petitioners in the event of the petitioners having participated in the proceedings. So nothing before. I had to go there on the date fixed for hearing, which was while the appeal was pending. Well, at the last day, when notice of hearing is given, when they're supposed to have considered my written objection, which was received at 3:45 p.m. and delivered the order on 15 March. And kindly note one thing, inspection report, disciplinary that action subcommittee, don't find mention in any document. First time in the order. So with the greatest of respect, how could I even have asked for it? When was I to be made known, about these documents? Now, it gets curiouser and curioso, kindly come to para 23 at page 48. Same stand. Document. Where is that annexure? Just tell me where. Page 96 now kindly turn to. Where is it referred to in the affidavit? Annexure R6.
Yes.
Paragraph 19, your lordship will kindly turn to at page 27. This should be the end of the matter. Kindly have a look. Middle of the page. Documents relied upon and you're perused by respond number 1 before passing the order are annexed. Such documents demonstrate. Not given. And they are from Millard. This is Millard, accountant, some accountant Millard, to whom it may concern. Millard R6, Millard documents pertaining to Dow Jones, etc. Millard right up to Millard pages 96 to 160. 109, sorry, 109 and then 160. They are neither mentioned. Now, this is very important. In the affidavit, they say they relied on it, perused it. This is not even mentioned in the order. And nor were they provided to the petitioners. My lord, 160 kindly, my lord, that's a wrong. My lord, in my note, my lord, sorry.
160.
160 kindly ignore. 96 to 109.
Right.
My lord, 160 had gone down by mistake.
So these were not referred to in the order also.
Also, and in the affidavit, they say we relied on these in passing the order. Now, my lord, one point which has not been answered. My lord, if the proceedings started in 2002 and by 2004, my lord, the stand was, my lord, clear. My lord, why wait, my lord, till, my lord, 2023 for, my lord, an order? And I've cited, my lord, our, my lord, High Court cases. My lord, if, my lord, they are kept pending, my lord, that's, my lord, both these. My lord, ITC Limited versus Special Director, and both are there. No? And Surendra Lal Girdhari Lal Mehta versus Union of India. My lord, both cases I had, my lord. Page 82, 83, 84, the 84, 85, 87 of the writ petition, of the GA, sorry.
Surendra Girdharilal Mehta and
ITC, my lord. My lord, they were, did we give a compilation?
ITC.
My lord, we had given a compilation not of cases, but my lord, circulars, etc., and cases were loose, my lord.
Yes. ITC, what is the section?
Versus Special Director, my lord. Eastern Region Enforcement Directorate, your lordship.
That's in the other file.
My lord, that was, my lord, an unreported judgment, my lord, in the sense,
No, this.
it wasn't an SCC online or anything.
Yes. তুমি ওটা নিয়ে নিচ্ছ, কিছু নিয়ে নেবে না, এটা এখানে থাক।
রাইট করেছিলাম তো, আছে তো তোমার। না তুমি যদি বলো হয়নি, I won't press it.
Probably I don't find in my the bunch of
What has
citations.
Then say so, na. My lord, ITC wasn't given, my lord. Surendra Lal, Girdhari Lal was given. You must note, don't give everything that I write. My lord, that is 2018 SCC Online Cal 2937.
Yes.
Same, my lord.
Yes.
And this was, my lord, a FERA proceeding,
Hmm.
which had, my lord, been kept pending, my lord,
Hmm.
for 9 years.
Right.
So, my lord, my preliminary, my lord, submissions had been, my lord, first dealing with, my lord, their case, that it's beyond the writ. My lord, I have, my lord, made every endeavor to show this is pursuant to, my lord, the, my lord, division bench judgment, and it's being used as a defense. My lord, so I have to challenge it. A decision has to be taken in that, my lord, to, my lord, prevent me from getting the reliefs I prayed for.
Hmm.
So, my lord, this argument, my lord, and second, my lord, they cited two cases. That case. No. Beyond the scope is what I want. Yes. My lord, the Jessup case, my lord, where, my lord, it said if subsequent our division bench judgment, my lord.
Yes, yes.
My lord, that was cited from Indian Kanun,
Yes.
which, my lord, is highly unreliable. My lord, but my lord, I had appeared in this matter, so my lord, I have not found any fault, my lord, in the.
Judgment was relied upon by us, but that was not an Indian canon. It's a company law journal.
What?
Another Indian
The
Kanun.
copy? No, the copy given to me is in Indian. In a conference, you might have relied on.
No, but
No, I know it.
Got in Indian canon. You
Yes,
never.
my lord, so did I, my lord, and my lord, but anyway, my lord, this was, your lordship recalls.
Indian canon is somewhat like Indian jugaad. There is a term for
Yes,
jugaad.
yes. But it's a good, my lord, it's a good, my lord, site to get cases which you can't find elsewhere. And then, my lord, usually there's an equivalent citation,
Yes.
and then one can go to that and quite often find, my lord, that what's been quoted, my lord, is not right. But at least it gives the case.
It has an AI flavor.
Yes, all these have AI flavors. My lord.
But I'm told that the premium subscription is pretty good. There's a premium subscription. One has to that.
But this may have a negative effect. I mean. Your
My lord, your lordships will find, my lord.
premium subscription. You have a premium of Indian canon.
No, this is not. This is not. The
Thank
one
God.
which we had cited was.
If you want to have, don't have premium subscription of Indian canon, please. I'm not against any company. Anyway.
Now, my lord, here, my lord, it's, my lord, paragraph 7, 16, and
22.
22 to 33.
Yes.
And, my lord, rule 53, my lord, had been relied on. My lord, referred to, my lord. In addition, rule 53 of our writ rules, which says, my lord,
Oh.
CPC, my lord, would, my lord,
Yes, yes.
Your Lordship had put a query, my lord, whether we are really.
Yes, that.
Yeah. But, my lord, be that as it may, my lord, on the face of it, my lord, clearly distinguishable, because it's a subsequent event which the division bench, by an order, has directed to be placed and taken into consideration, my lord, for disposal of the petition. And that is what has been done. And, my lord, the rule for this, as your lordship has pointed out, and, my lord, which is there also in the division bench judgment, that, my lord, the other side, my lord, has an opportunity to deal with it. Here I've disclosed it in GA, my lord, 1. They filed an affidavit, my lord, dealing with both the writ petition and the GA. So they've had ample opportunity. And, my lord, fortunately for us, my lord, in, my lord, taking advantage of that opportunity, they have also disclosed that in making the decision, they relied on materials which were not, my lord, in the show cause or in the order.
Yes.
Yes. Now, point. That's different, please. Now, my lord, the other case was Bachaj Nahaj, my lord, which was relied on 2008 17 SCC.
Yes.
My lord, paragraphs 10 and 20. My lord, I'd like to read, my lord, 10, because I think this helps me. My lord, kindly see the High Court. My lord, to start with, this was a second appeal, my lord, case. My lord,
10
where
to
your
30.
lordship had put the query that this is CPC.
Yes.
Then, my lord, rule 5. But, my lord, apart from anything, it helps me. Now, kindly have a look.
10 to 13 was placed.
Yes, my lord. 10.
10 to 13.
Yes,
10,
my lord.
11, 12 I have at least marked.
My lord, I had.
Oh, same.
Yes. My lord, it's by and large the same till 20.
Yes,
My lord, I'll just place para 10. The High Court in this case, in its obvious zeal to cut delay and hardship that may ensue by relegating the plaintiffs to one more round of litigation, has rendered a judgment which violates several fundamental rules of, kindly note, civil procedure. Rules breached are: no amount of evidence can be looked into upon a plea which was never put forward in the pleadings. A question which did arise from the pleadings and which was not the subject matter of an issue cannot be decided by the court. A court cannot make out a case not pleaded. Court should confine its decision to the question, nor can it grant a relief which is not claimed and which does not. A factual issue cannot be raised or considered for the first time in a second appeal. Now, my lord, my lord, stop here. My lord, and my lord, make this submission to your lordships. Here they've had an opportunity to deal with. They've accepted the division bench order. Nobody has gone up on appeal from that. My lord, that operates, my lord, that's an order binding on all the parties. Now kindly have a look at 13. The object of issues is to identify from the pleadings the questions or points required to be decided by the courts so as to enable parties to let in evidence thereon. When the facts necessary to make out are not found, court cannot focus on the attention of parties or on its own attention on that claim or relief by framing an up. As a result, defendant does not get an opportunity to place facts. Cannot go on finding has made out the case put forward, grant some other relief. Question before is not whether there is some material on the basis. Question is whether any relief can be granted when the defendant had no opportunity to show. My lord, here every opportunity you go back, and that is what is being relied on. Once, my lord, they rely on this decision to deny me, my lord, the relief. My lord, I can assail it, even if I didn't have, my lord, the order of the division bench. Now, my lord, another argument, my lord, was, my lord, advanced. My lord, that, my lord, interlocutory relief, my lord, cannot go, my lord, beyond, my lord, the final relief. GA2 is not interlocutory relief.
That I noticed.
GA1, sorry, my lord. GA1 is not interlocutory relief.
Post remand.
Yes.
Rather leave.
Correct. Yes. Now, my lord, on this case of, my lord, disputed question of fact, etc., my lord, I am not going to cite any new cases. Your Lordship's fully aware. My Lord, ABL International, etc. They've said, but my Lord, most important is, I am not, my Lord, bringing up any fact which is contentious. I am saying, my Lord, what am I saying? My Lord, I am saying on your own showing, this is a show cause notice. Number two, none of your communications, including what you describe as a show cause notice, on the face of it, my Lord, show, my Lord, that, my Lord, I am being told that you are liable, and unless you reply with material, you will be found guilty, so to say.
Yes.
Now, my Lord, third, documents which were never made available to me have been relied on. And to cap it, my Lord, documents relied on have also not found place in the order, let alone the show cause notice. Fourth, my Lord, the constitution of the committee is itself bad. My Lord, your Lordship had, my Lord, put questions to, my Lord, Mr. Ray, my Lord, on, my Lord, managing director was there, he could be treated as a shareholder director. But, my Lord, quorum wouldn't have been there. Lordship pointed that out, my Lord.
Yes, yes.
In, my Lord, the regulation. So, my Lord, they in fact had no jurisdiction. Fourth, they've relied on adjudications against me, where, my Lord, adjudications have happened behind my back, and I have not even been furnished those in the show cause notice. They come out for the first time, my Lord, in, my Lord, the order. My Lord, your Lordship recalls, my Lord, the notification my learned friend relied on. My Lord, this was a one-pager. That, my Lord, if there is a vacancy of a managing director,
Yes.
the requirement is of all three under the composition, my Lord, Rule 23 of the governing board. And, my Lord, managing director will be included in the category of shareholder. My Lord, that's in my compilation. Now, kindly see, my Lord, you don't have to have an MD. But that doesn't mean, and this was given specifically to Calcutta Stock Exchange because its affairs were being wound up. And, my Lord, shareholder director requirement, my Lord, remains Rule 23. And there was none. All the three directors, my Lord, who signed the decision, my Lord, were public interest, my Lord, directors. My Lord, your Lordship has a look at the rule once, my Lord. Tab 4, my Lord, of the compilation we'd given.
Now, compilation.
Tab 4, my Lord.
Yes.
My Lord, this is, my Lord, the security contract regulations, stock exchange and clearing corporations. Kindly come to Rule 23, my Lord.
23 years.
Composition of the governing board. The governing board of every recognized stock exchange and recognized clearing corporation shall include one shareholder director, public interest director, and managing director.
Yes.
Then, my Lord, kindly note, my Lord, one thing. 3, number of public shall not be less than number of shareholders, etc. And, my Lord, then, my Lord, there are bars on who can be appointed, my Lord, a director. And then, my Lord, 11 shows that shareholder director have to be there. The voting on a resolution in the meeting of the governing board, my Lord, Rule 11, my Lord, 2311, shall be valid only when the number of public interest that cast their vote on is equal to more than the number of shareholder directors who have cast their vote on such resolution.
Achha, this regulation 23 sub-regulation 4 says the managing director shall be included in the category of.
Correct. So, my Lord, that's fine. But there's no managing director here.
Oh, yes. Right.
There's no managing director. My Lord, if they had one, then there would be one shareholder director.
That is precisely what you said
Yes.
a few minutes back. Yes.
And my lord, 10, my lord, 2310
Yes.
shows, my lord, that quorum issue, the number of public interest directors shall not be less than the number of shareholder directors to constitute the quorum for the meeting of the governing.
Mr. S says they were more. I mean, because
Yeah, there was none. But it contemplates, my lord, there has to be, my lord, a shareholder. In fact, my lord, the first 23(1) says 3 categories of directors, and it must have. Then it says, my lord, managing director will be treated as a shareholder director. Because, my lord, the shareholders vote, my lord, for appointment of a managing director. So, my lord, it makes sense, my lord, to say, my lord, that he will also be treated as a shareholder director. Here, no managing director. That doesn't mean, my lord, other shareholder directors can't be there. And they've appointed one. Just after I filed the GA, my lord, they go ahead and appoint it. That's in the affidavit in reply, my lord. I've annexed that document. Now, my lord, this defaulter subcommittee, my lord, I want to show, my lord, what, my lord, the stand is. My lord, kindly take the settlement, my lord, the rules, the compilation, my lord. Tab 6. Now, my lord, kindly come to page, my lord, of tab 6. My lord, kindly take, my lord, the internal page 12. Page numbers at the bottom.
Yes.
My lord, kindly see limitations of liability of the fund. Your lordship's attention had been drawn.
Yes.
So, my lord, liability of settlement guarantee fund would cover all transactions put through C-Star system in the normal course of trading. Except, my lord, kindly forget the first 2 and the last 2, any fraudulent deals or non-bona fide transactions. They are putting us in the category of, my lord, non-bona fide transactions. Now, my lord, kindly come to, my lord, page 15.
Yes.
If a member fails to pay any amount payable by him into the clearinghouse in respect of any transactions entered into by him, then within 24 hours of such failure, the member and the clearinghouse shall inform the president and executive director in writing of such failure and of the extent of the unfulfilled obligations and commitments of the member. Now, my lord, here we had sold the shares belonging to our clients. So, Doe Jones, my lord, who was acquiring on behalf of his clients, failed to put, my lord, pay. He should have, my lord, informed, my lord, the settlement. Then, my lord, he, my lord, would then get declared as a defaulter member. My lord, I'm not, then payment under settlement guarantee. Upon a member being declared a defaulter, if the settlement in which the defaulter has been declared a defaulter has not been completed by reason of default of the defaulter's subcommittee shall pay into the clearinghouse before the payout of the relevant settlement the unpaid settlement dues payable by the defaulter into the clearinghouse. Within 11 working days from the date of payout, deliver the securities to be delivered by the defaulter where they are to deliver, my lord, in respect of settlement. Whereas, so, my lord, they have, my lord, time here. My lord, first the money comes in to, my lord, the clearinghouse. From, my lord, the settlement guarantee fund. Now, my lord, kindly see what happens. B.
Yes.
Notwithstanding anything elsewhere stated elsewhere in the rules, bylaws and regulations, if the defaulter subcommittee has reason to believe that any transaction is not bona fide, my lord, kindly ignore, my lord, B and C, then if the default amount involved in the payout or the transaction value or the market value of the concerned transactions referred to so-and-so is rupees 50 lakhs or more, defaulter subcommittee shall record the reasons for its belief and shall not make payment or deliver securities out of the fund in respect of any transaction which is of such a nature. Then can we come to the next, which was, my lord, they, my lord, suddenly realized, my lord, a 2001 transaction, 2004, my lord, they say, 2002. Now, my lord, if for any reason any payment is made or securities are delivered in respect of any such transactions, the concerned receiving member shall repay such amount or re-deliver such securities to the defaulter subcommittee within 48 hours of being required to do so and in accordance with so and so. Now, my lord, kindly come to page 17.
Who will be the receiving member here?
My lord, I, according to them, my lord,
Because
my lord, Dow Jones defaulted.
yes,
So, my lord, this money which is in the settlement guarantee fund,
Yes.
my lord, was paid to me
Right.
for, my lord, the transaction amount. Then, my lord, shares, my lord, are taken by, my lord, the settlement guarantee fund or, my lord, the defaulters committee, and they, my lord, then sell those shares.
Okay.
What they said was, what we have paid you,
Hmm.
we recovered 2.11 crore less.
Hmm.
So, because it was not a bona fide transaction,
Hmm.
you have to repay this. You have to make good this shortfall.
Hmm.
This was, my lord, their case. Now, my lord, kindly have a look at page 17. My lord, third para, defaulter subcommittee.
but that's Mr. Mukherjee, sorry, I'm just because apparently, as per the previous clauses which you read,
Yeah.
If it's not a bona fide, the language used is uh, any fraudulent deals or non bona fide transactions.
Yes,
So then the SGF does not have any liability at all.
correct.
Then the entire thing ought to have been paid by
Reversed.
you.
Yes.
Reversed. Yes.
Reverse. So I would have got back the shares. They didn't give it back to me.
Yes.
They sold the shares.
Right. They didn't do that. I mean,
They sold the shares.
they did not have any liability in the first place, which I asked Mr. Rai also.
Correct.
He gave some answer. Yes.
Now, my lord, here, fact of the matter is, before, my lord, they say they woke up, the transaction is done on their platform, the C Star. Before, my lord, they say when they woke up,
Work is an abuse now.
your lordship is right. My lord, before they awakened, my lord, and my lord, what happens, my lord, is they say, well, sale has happened. We have also sold. We have also sold it, but we made a loss of 2.11. So you pay us. Now, my lord,
Yes.
there has to be a determination of it not being a bona fide transaction.
Yes.
It's not on whims and fancies.
Hmm.
Now, kindly come to page 17.
Hmm.
My lord, third paragraph. The defaulter subcommittee shall afford an opportunity to the concerned members to be heard by giving them not less than 24 hours written notice before finally determining whether the transaction is a disallowed transaction. Absent. Now I want to show your lordship, my lord, there's no dispute about this.
Hmm.
And my lord, the important thing is, my lord, just 2 paragraphs after that para, same page, defaulter subcommittee shall determine whether or not a transaction is a disallowed within, kindly note, 1 month from the date of the relevant payout. This is also binding on them.
But there is no consequence. If I mean, this may be argued to be directed.
Yes, let us take it as directly,
But
but
1 month and
has, my lord, and has to be, I have to be heard.
yes, obviously.
Yes, and that has not been done. Now, my lord, important thing is, kindly have a look at their affidavit, what they say. Page 36. My lord,
Yes.
my lord, affidavit in opposition, page 36, to the GA, my lord. My lord, they seem to suggest that they don't even have a defaulter subcommittee. My lord, page 36.
Yes.
My lord, middle of the page,
Yes.
my lord, after 2.11 crore,
Hmm.
next line, I deny that the decision taken by the respondent regarding issue number 4 as stated in the order dated 15 March 2022, passed by the respondent, is in violation of the regulations of that respondent or that regulation 17 of the bylaws and regulations, continuation to chapter 18 of the respondent contemplates a constitution of subcommittee or a procedure for determining and declaring a default. So not even happened. There's not even such a subcommittee.
No, they say in violation. They deny that it is in violation.
No, and then Miller, that contemplates a constitution of a subcommittee. That's the defaulter subcommittee, which is to decide it.
No, but the entire sentence is I deny that the decision taken by the such and such is in violation of the
Regulations or that regulation
No, of the-
20, 27 of the bylaws and regulations, continuation to chapter 18,
Yes, yes.
contemplates a constitution of a subcommittee.
Right.
Well, the simplest thing would have been to show that this decision was taken by the defaulter subcommittee.
They also referred to that in their order. The defaulter subcommittee.
Disciplinary.
All right.
That's my lord for 6 lakhs.
Yes.
Defaulters is for a non-bona fide transaction, which is the basis of 2.11 crore. My lord, it's not there in, my lord, the order. It is not there, my lord, in any of the correspondence. And, my lord, most importantly,
Deny that it is required.
required. And, my lord, in page 168, I'm grateful to my learned juniors, my lord. Page 168, my lord, kindly have a look what has been said. This had skipped 168, my lord. Kindly take the just above the operative portion.
Yes.
The board has decided to pass the aforesaid order against Dalmia Securities in terms of CSE's inherent rights under various inherent rights under various applicable rules, regulations, as vague and vague as
the acceptable rules.
yes,
So therefore,
under various acceptable rules. However, insofar as the dereliction of duties and statutory framed by SEBI, board has decided to forward its finding to SEBI for appropriate action against Dalmia.
yes.
And the finding is, my lord, that it's a non-bona fide transaction. And, my lord, we said nobody is saying, my lord, that the trades didn't happen, my lord, in close proximity. My lord, both buyer and seller, my lord, going on. But, my lord, what has to be shown, my lord, is, my lord, insider trading had happened with the intention to cause loss. So, my lord, I ought to have known when I entered into, both of us ought to have known that, my lord, we will cause loss to, my lord, the SGF, the Settlement Guarantee Fund. That shares would sell for a lower price if Doe defaulted in making payment. Page কত? Now, my lord, the arbitration clause, my lord, which my learned friend, that's another point which was taken, that there's an arbitration clause. This is a contractual dispute. My lord, your lordship will find it in my compilation, my lord. Last 4 pages. Clause 21. Oh, sorry, 31.
Clause 31 of
My lord, page 20, internal page 20, my lord, at the bottom. Last 5 pages of the compilation.
this compilation, the one
Yes,
which
ma'am.
you are referring to.
Yes, ma'am. Your lordship will find the last page, I think, is form of application to settlement. My lord, just 3-4 pages before that. Page 20, my lord. 22 is the regulations, 21, my lord. Then
No, I'll just hand it over to
Yeah.
your juniors.
nahi.
Is that one?
Huh?
On the last one.
My lord, 2 additional documents were put in during the course of arguments, I think. That's why.
Yes, yes.
My lord, page 20.
Yes, that.
Yes, my lord, first submission I make, my lord, that arbitration clause, my lord, cannot stand in the way of, my lord, it's merely because there's an arbitration clause. And here particularly, my lord, as I am, my lord, assailing the decision on the ground that, my lord, there have been breach of the principles of natural justice, completely arbitrary, and, my lord, should actually have been, my lord, not proceeded with at all, considering, my lord, first, their order. My lord, there are 3 orders of SEBI. I've shown your lordship only one. 3 orders of SEBI, and, my lord, one of them covering, my lord, off-market transactions for that period, which I'll show, my lord. And, my lord, thirdly, my lord, 82 khali noy, aro 3 page ache. And, my lord, this arbitration clause, in any event, my lord, is, my lord, possibly not valid.
Why?
My lord, because, my lord, the executive director of the,
Oh, acha, acha, acha.
my lord, we are dealing with the schedules, my lord. This, my lord, squarely, my lord, falls foul. Our cases ki ache. My lord, I'll quickly deal with their cases, my lord. Yes, my lord. One other point which I had made at the start, my lord, the impugned order, my lord, in fact, my lord, your lordships will find, my lord, does not consider the case, my lord, which we had made out in all our responses, my lord, to, my lord, the letters, including, my lord, the show cause which was issued, my lord, while, my lord, the appeal was pending. Now, my lord, on disputed question of fact, পুরা সাইড করেছিল হ্যাঁ তো এখানে আছে তো অনির্বাণ রায়
Disputed question of fact is, you said it is not a,
yes
you're not arguing any disputed
yes
question.
I'm not, my lord. They cited a case. They cited
Yes, they
cases,
did.
my lord.
Yes,
Yes, my lord. 2005, 5 SCC 581,
yes.
para 7 to 8. My lord, my respectful submission, my lord, is, my lord, here, my lord, in any event, my lord. My lord, your lordship need not trouble, my lord, with the cases. I'll put it in the note. I'll just indicate, my lord.
Yes.
Disputed question of fact, my lord. My lord, here, of course, the disputed question was in a criminal investigation, apart from anything else.
Interference in contractual matters and disputed questions.
Yes.
That's the head note.
Yes.
State of Kerala.
No, your lordship's looking at state of Kerala. No, my lord. I'm first looking at,
Oh.
my lord, 2005, 5 SCC 581.
Oh, all right. Yes, very well. Yes. Yes, police in action.
Yes.
Right.
Now, my lord, here, and my lord, Kerala, my lord, your lordship kindly takes. My lord, this was, my lord, a termination of a works contract. Then, my lord, another case was relied on, 2023 SCC online, SC 614. My lord, which is, my lord, I'll give your lordship the reported, my lord, citation. The citation of the report, my lord, 2024, 12 SCC 614.
2023.
My lord, the case is BTL EPC.
I don't find.
My lord, does your lordship have 2024 12 SCC in case that had been given? Oh, SCC online is what I indicated. BTL EPC Limited.
Did they at all cite it? I don't think.
My lord, I have a noting on it, so I'm sure, my lord, the other side would have cited. My lord, they say, my lord, whatever case I refer to saying I must have cited, they say I have not cited. So I say, okay, very well. But my lord, their cases, my lord, I know, otherwise I wouldn't have made a note.
Did you cite this, the one 2020?
BTL EPC Limited, 2024 12 SCC 614,
Either
which
that
is
or
equal to
2023.
2023 SCC online 614.
No, we had not. We had sought to, but we had subsequently not done that.
Yes, yes.
I was given a copy, my lord. So,
They came up to 2021.
yes. So, my lord, just one more case remains. My lord, that's the prejudice test of
Yes.
1984, one Supreme Court
Yes,
cases,
yes.
43.
Yes, yes.
And my lord, here, my lord, clearly, my lord, prejudice. My lord, it, my lord, affects me, my lord, in my line of, my lord, business. And
No, prejudice.
no, my lord, the order itself. And then, my lord, the fact that I wasn't given a hearing,
Yes.
my lord, is prejudice because I was never ever informed, my lord, of these charges. My lord, they've relied on, my lord, they say defaulter subcommittee was to decide this. My lord, as per the regulations, I say so. They say, oh, it's not necessary. It's not even required. And my lord, the disciplinary committee, my lord, I was not even aware that 6 lakhs, my lord, has been, and this is not disputed. And most importantly, they relied on documents, my lord, which are not in the order, not in any of the letters to say, my lord, they relied on it for passing the order.
If you are given a hearing, you could have pointed this
Yes,
out.
I've said so in my affidavit.
Yes, also.
Correct.
Yes.
My lord, these are, my lord, কি বলছিল? And the prejudice test again is, my lord, the most recent one is 2021 19 SCC 706. Sure.
They can know. That's all.
Yes, ma'am.
Would you like to file your written notice?
2 weeks time.
2 weeks.
Because I suppose that it's been a long while. Mr. Mukherjee had also made his submissions, which were perhaps
My lord, I was entitled to, my lord, in reply.
on not
No, but
perhaps
no new submission had been made. You have concluded long back.
perhaps,
Should
the
be ready
supplement-
already with your written notice of argument.
supplementary affidavit, my lord, was not dealt with.
Your written note should already be.
But nonetheless, my lord,
Then if you want 2 weeks, we'll give it to you. No difficulty. Need not be inconvenienced.
the 19th of December, my lord.
Very well. Oral arguments are concluded. Full stop. On the prayer of learned counsel appearing for the respondent stroke CSE, comma, the matter is adjourned till December 19, 2025, when it will be listed under the heading to be mentioned for the purpose of filing of written notes of arguments by both parties. Thank you.
Mention that, Lordship, I have some personal obligation or commitment to attend today. I will be leaving court. If it can be taken up next week,
Today we have to continue up to 3.
3:30. Yes.
Oh.
I'm for the petition in item number 5.
If it is called on, keep someone, you are there. So just, he also has that commitment.
No, I will be leaving court. That is.
So you ask, pray for time, inform the other side just.
I am here.
Yes,
I'm
yes.
for the petition.
So very thale 5 ta thale na কিছু order record করতে হবে না, not to record রেখে দেবে কল করো।
Next week. I'm extremely upset.
But we are for the respondents.
Yes, Mr.
I think not the petitioners are not interested. The NCLT has passed that a plan has been accepted, approved. I think that's why they are not appearing.
Huh?
मतलब 5 दिन
What was the challenge against Mr. Ghosh?
But the challenge in the writ petition, Lord, they claim that in view of failure on the part of the bank to provide them enhance the loan facility, they have suffered, and accordingly they approach before this honorable court.
Acha. So the CIRP was going on at that point of time? The subsequent
No.
or subsequently started?
Yes.
Acha, so you are directed to file affidavit in opposition in any event?
Yes, we have filed.
You are filing today?
Yes. In terms of my lord's last order,
Yes.
last 3-4 occasions they are not appearing. Maybe for that reason.
Maybe. Right. So if the resolution plan has been accepted,
Yes.
But affidavit in opposition, affidavit in opposition filed today be kept on record. Push up next para. Learned senior counsel appearing for the respondents submits that the company, the petitioner company underwent a corporate insolvency resolution process, which has culminated in a resolution plan being approved. Push up next para. A copy thereof is handed over in court today and kept on record. Push up. It transpires that on the last few occasions, none had appeared to move the matter on behalf of the writ petitioner, apparently due to the pendency of the resolution process. Push up next para. In any event, since the petitioners remain unrepresented today as well, WPO 1804 of 2023 is dismissed for default without any orders to cost. For some interim orders, if any, stand vacant. Thank you.
Petition number 1 হবে
It transpires from the records that on January 17, 2025, when the matter was called on for hearing, the matter was adjourned on the prayer of the parties. First up, thereafter, on May 16, 2025, none had appeared for either of the parties, and as such, the matter was again adjourned. For sub next para, on November 7, 2025, on the prayer of the petitioner, the matter was adjourned as well. First up, even on November 14, 2025, at the time of call, none appeared for either of the parties. For sub next para, accordingly, it transpires that the petitioners are no longer interested in moving the matter. Accordingly, WPO 907 of 2016 is dismissed for default without any orders to costs. Interim order, if any, stands vacated.
Lord, I am for the petitioner, my lord.
Yes.
This is a changed brief. My lord, on 21st of November, my learned friend served a copy of the opposition to a supplementary. But I have not been able to trace the supplementary records.
You take copies from your learned friend.
Yes, but I don't know.
Immediately I have served. I have
I'll
RDF,
coordinate and will not take that.
ISR, and my learned friend also.
Oh, then
No, my lord, my supplementary I can't find, but the opposition. I've
no,
got.
no, the supplementary. He will take a
This
copy
is
of.
opposition to the supplement.
He will take a
That
copy of
is-
the other papers which are missing from his record.
Right.
His own papers. So please just cooperate with him. Furnish the papers so that he can take out photocopy.
And but I'll also file a reply to this opposition, my lord, because it's been served on 21st of November.
Very good.
Although I find it was affirmed in April 24.
So, but then we'll extend the time for a week then for that
Not
because
kindly.
it's already ready.
Yes.
You
No,
have
no,
to
my
just-
lord. The opposition I've received, I have to file a reply to the opposition.
So how long?
My lord, kindly keeps it on 19th, my lord. In the meantime, my lord, I'll.
Well, then, my lord,
After vacation, very good. Please hand over the affidavit in opposition filed today be kept on record.
No, to the supplementary
to
affidavit.
the,
As
to
affidavit
the
of
supplementary.
affidavit in opposition to the supplementary affidavit, filed today, be kept on record. Full stop. Learned counsel for the petitioners, appearing on change submits that that the papers of the matter are not being traceable in the office of the petitioners. Full stop. Accordingly, on the prayer of the petitioners, the time for filing reply to the affidavit filed today is extended till December 19, 2025, when the matter shall next be listed for hearing. Sorry,
No, ma'am, after
December 19, 2025, তারপর full stop. Whenটা হবে না? Full stop. The matter shall next be listed on January 9, 2026. 9. Supplementary affidavit file হয়নি?
নামটা দিয়ে
I'll trace out, my lord. I'll try and trace out. Recording নেই না?
At this juncture, at this juncture, it transpires that the supplementary affidavit, to which the affidavit in opposition has been filed today, is not yet on record, full stop, in view of the handicap expressed by learned counsel for the petitioners, the petitioners are permitted to file a photocopy thereof on the returnable date. Please take copies from them
No,
and
I'll-
file an extra copy. It's your copy. হয়ে গেল অ্যাপেল সাইড None appears for the parties at the time of call. Push up. Let the matter stand adjourned till December 12, 2025. Same. It appears from the office report dated December 5, 2025, that two civil rules are pending in connection with the matter. Full stop. Moreover, no paper books have as yet been filed by the appellants. Full stop. Since none appears for the parties at the time of call, let the matter stand adjourned till December 12, 2025. By an order dated November 28, 2025, it was recorded that none had appeared for either of the parties, and accordingly a last chance was given to the appellant to appear and argue the matter. Full stop. However, even today, at the time of call, none appears for either of the parties. Full stop. Accordingly, SA 852 of 1965 is dismissed for default without any orders to cost, whose of interim order, if any, stands vacated. I have no dismiss for default fault হয়নি তো চেক করে নেবেন একবার তোমরা replement.
5 Lordship, I beg to appear on behalf of that person, my lord.
You have checked up?
My lord, I have checked up. They have yet to supply me the service book copy, which they have reconstructed. As it appears from their communication, they have sent it to the AG office. But my lord, the copy is required to be given to come to a final conclusion. So far, they have paid, my lord.
What was the order under contempt?
My lord, kindly, my lord, 21st August 2023. What is more, my lord, paragraph 32 is also required to be considered by them. Subsequently, by an order, this Honorable Court directed them to purge out from contempt by 26th September 2025.
Just let us see the first order.
My lord, first order dated, my lord, 20th August 2023. Thereafter, appeal, and finally, my lord, appellate court affirmed the order of this Honorable Court.
Has been given the entertainment of
I am drawing lordship attention, paragraph 30.
Yes.
Relevant portion in, my lord.
32.
30. First 30, then 32. Allowed on contest directing the respondent number 7 special officer government to disburse the entire retirement pension benefit of late Shochiputi Ghatok, an ex-employee of Katwa Subdivisional Hospital. Such pensionary benefit by applying the appropriate scale of the entire period till the demise of Shochiputi Ghatok, December 28, 1981. Lordship, kindly recollect, firstly they have done 5 years they have taken into consideration, remaining period they have termed it a non-dias none. Then we draw the attention, Honorable Court was kind enough, and my lord, that particular order prompted them, my lord, to come to a conclusion, and they are trying to do their conclusion, but yet to be, my lord, release all the money and pending. My lord, 32 may kindly be looked into. The respondent authority are also directed to consider as to whether either of the petitioner is entitled to family pension on the demise of late Shochiputi. One of the daughter is widow daughter. She is also entitled. We don't know what is going on so far this widow daughter is concerned. Then, my lord, kindly see the order passed by this Honorable Court on 3rd September 2025.
Who is the other petitioner?
My lord, the son and daughter is widow. Here, my lord, 3rd September 2025. My lord, I am drawing paragraph 13. Secondly, the treatment of the period between so and so and dias none was palpably contrary to the direction of this Honorable Court, by which the respondent authority had to disburse within 2 months. Then I am drawing lordship attention, paragraph where lordship was kind enough to direct them to pay the whole amount on 23rd 9 2025, directing them, my lord, paragraph 4, on the basis, paragraph 3, my lord, upon query of court, learned counsel for the alleged contemner assured the court that the admitted due amount by way of retirement benefit of the deceased employee predecessor in interest of the petitioner shall be paid to the petitioner by September 26, 2025. That is by the end of this week. On the basis of such assurance, the alleged contemner are directed to stick to their assurance and pay the amount to the petitioner by September 26, 2025. Then, my lord, 26 September 2025, they have paid us, my lord, the leave salary and, my lord, group insurance. Then we draw the attention. Now they have sent one document showing that, my lord, the entire dues so far the Bhoktirani, my mother is concerned, 3,30,000 maybe, my lord, that to be paid to us, though we have yet to receive that particular amount. And so far the widow daughter is concerned.
Your mother is not alive.
He died in the year 2006. And thereafter, my lord, myself is, my lord, the widow daughter is, when a widow daughter, she is also entitled. At the same time, now, my lord, we are drawing before this Honorable Court the service book copy as well as, so for the fate of the widow daughter, they are required to be, my lord, taken a decision, and the amount is required to be sent to her account.
The decision was taken as to who is whether you are both entitled.
Not that the son is not entitled, my lord, admittedly, but the widow daughter is entitled to get the family pension.
They paid the leave benefits and those.
Both of them divided. We have no objection so far that part is concerned.
But if the son is not entitled, how are you?
No, but the son is entitled so far the father's money is concerned, my lord, deposited in the leave account. That part is divided. But the family pension, again, my lord, Bhoktirami's pension is to be divided amongst the son and daughter. But so far the widow pension is concerned, here the daughter is only entitled. That being the situation. So far there is, this part is concerned, no whisper. and we are yet to receive the service book which they have sent to the AG. My lord, the service book.
Service book we understand, but Mr. Chakraborty, the wages for that period was not paid to you.
No. No. Not paid. It was initially, my lord, as diasnon, thereafter direction was
directed to pay retirement benefit.
entire retirement benefit. Entire retirement benefit.
So they are saying that they have paid the entire retirement.
No. Entire retirement benefit means, my lord, including the question of area pension, so far the daughter is concerned, as well as the mother is concerned.
Mr. Chakraborty, that would give rise to a fresh cause of
Well,
action.
two part, kindly visualize, my lord. 2016, the matter is pending.
As per their, whatever is there, the dues as per their stand, they have paid.
No,
now it cannot be said that in contempt we will not adjudicate whether that is the
but subsequent order, my lord,
beyond the
because diasnon and all this question and service book, my lord, why they are hesitating to
that
supply?
one was a direct violation because they could not say that in view of in the teeth of the order.
No, well, true, my lord, they cannot.
They now it boils down to the quantum. So they are saying that they have paid the entire amount.
No, we are yet to receive. This 3 lakh is yet to be received. That being the situation. And my lord, the question of widow pension, no decision has been taken. Paragraph 32, Lordship was directed them to take a final decision. That is the main order, my lord. That is the order dated. My lord, Lordship will find from the 21 August 2023.
Yes, yes.
Paragraph 32.
Entitlement.
Entitlement. My lord, I am entitled by the order of the.
So what about this, Ms. Sinha, regarding this entitlement? Who is entitled to the family pension? And what about non-payment of that family pension?
Lordship, let me go one by one. He will agree that it has been disbursed.
Gratuity not, ma'am.
Okay.
Only, my lord, the leave.
I'm telling about everything that you have received, which you had.
Yes, Ms. Sinha, what else?
Yes.
I'm showing, my lord, the document lying with me.
Pension released. Daughter pension, which he has just mentioned, your lordship, we have already decided that daughter will get the pension. We will just release it. And with regard to service book, which he has just mentioned, in our report dated the 13th of November, which I have already supplied him a copy. The second paragraph says that, yes, it is with the AG Bengal. We will also do that. If he makes an application, one humble submission before your lordship, if lordship agrees with me, let him make an application before the concerned Katwa he was serving. I think they will supply.
No,
remains.
regarding the payment, then you say that the widow,
Yes.
regarding the daughter, it has not yet been paid.
Yes.
So you file a compliance report.
Lordship,
Mr.
comprehensive compliance
We'll
report.
keep it
will go.
next week.
Lordship.
Learned counsel for the petitioners alleges that the entire payments in terms of the order of this court dated August 21, 2023 and the subsequent order of this court dated September 3, 2025 have not yet been paid to the petitioners, nor has the entitlement of the widow daughter of the deceased Shochipati Ghotok been decided by the alleged contemners. Next para. As such, it is alleged that the contempt committed by the alleged contemners has not yet been purged. Learned AGP appearing for the state alleged contemner controverts such allegations and submits that all the dues in terms of the orders of this court have been cleared apart from the entitlement of the widow daughter, which is in the process of being disbursed. Next para. Accordingly, the alleged contemners are directed to file a compliance report on December 12, 2025 with an advance copy to the learned advocate for the petitioners, disclosing therein the relevant documents in respect of such payments as well as the pleadings in that regard. Next para. The matter be listed next on December 12, 2025 under the same heading.
Lordship, may I most humbly point out, in our compliance dated 18/9, there is a paragraph. Further, the extended benefit of family pension may be granted to the widowed daughter of late Sachipati Ghatak, that is Srimati Aruna.
Further complaints report ko no, you have to disclose also regarding this payment. Pay the daughter in the meantime.
Deeply obliged. Deeply obliged.
With full compliance, we require full compliance. As per your admitted whatever are the dues, that you have to comply. Pay and come back with that compliance report.
Lordship has fixed the matter on?
Next Friday?
Lordship, can it be?
But 19th. The 19th.
Meanwhile,
pay in the meantime.
Meanwhile, my lord, service book is also
that
line
in the scope of contempt.
directed once. My lord, deeply obliged.
That direction was not there. Whatever was there, I will comply with.
Yes.
Yes,
May I
great.
please submit one thing to the
Yes, yes,
because
please do.
in the main order, parent order, where from the contempt has been arising.
Yes.
It has decided who who is having the entitlement to get the family pension. That we have decided that the
Daughter.
who is entitled.
Disclose that in your complaints report also.
And
Just that decision of yours, just annex that.
yes,
Whatever
there.
in support of this,
There.
whatever your that is there.
There we
Please
have-
annex another copy. But
But
I actually want the payment to the daughter.
Yes, payment to be started.
Everything to be completed within these 2 weeks.
to make a categorical compliance
Yes.
report.
Yes. Yes.
Grateful, Your Lordship.
Thank you.
Item number 6.
सब मिक्स हो जाए.
On November 28, 2025, none had appeared to move the matter. So even today, at the time of call, the petitioner in the contempt application is not represented. Accordingly, CPN 534 of 2020 is dismissed for default without an order to cost.
Item number 7.
My lord, item 7, I am for the alleged contempt. Your lordships kindly consider, my lord, the appeal court has already, my lord, decision of the matter.
Oh,
No, not set aside, my lord. It is in process. So they appeared and they prayed for time to file a comprehensive documents which relied upon the read court.
Since it is pointed out that it is pointed out by learned counsel for the alleged contemner that the appeal court is in season of the appeal preferred against the parent order, for the sake of propriety, let the contempt application stand adjourned and be listed next on January 9, 2026.
Well, may it be extended. At
9th
least,
January.
well, in the meantime, we shall take steps because
Very well. January 16.
vacation is knocking at the door.
January 16, 2026, 2 weeks after that. January 16, 2026.
Great.
Item number 8.
Item 8, my lord, my oral instructions that we have complied to your lordship's order. But in written, I am...
Put it on paper, give a copy.
Yes, my lord. I have asked them to...
Learned counsel for the alleged contemner submits on instruction that the order of this court has been complied with. Accordingly, the alleged contemner shall file an affidavit of compliance. Alleged contemners shall file an affidavit of compliance in that regard on December 19, 2025 with an advance copy to the petitioner. The matter shall be listed on December 19, 2025 for such purpose.
I'm grateful. Your lordship directed one connection, another disconnection. That has been done. That has been done. Madam,
disconnection you have done. Connection you are not giving.
Yes. We have effect connection and we have disconnected also because your lordship's order is twice.
Oh, in the same order?
Yes. Your lordship direct us to disconnect one connection and effect another connection.
Item number
Great.
9 to 11.
On November 28, 2025, none had appeared to move the matter at the time of call, Even today, none appears to move the contempt application, Accordingly, CPN 1234 of 2024 is dismissed for default without an order as to costs.
Item number 12.
আগেরটা প্লুরালে করে দিতে হবে মেঘনা সেম অর্ডার এটা সিঙ্গুলার CPN 1420 of 2024.
Number 13.
I appear for the contemner lordship. We've
Yes.
been served. That's all I wanted to tell the court.
None appears for the petitioner at the time of call, although the alleged contemner is represented through counsel, who submits that no copy of the contempt application has been filed as yet. Next para, it transpires that on November 28, 2025, when the matter was taken up last, none had appeared to move the contempt application. Since the petitioner is unrepresented even today, CPN 1458 of 2024 is dismissed for default without an order as to cost.
দিয়ে দিলাম যে
24. That. My lord, in this case,
the petitioner, my lord.
Lordship kindly remembers, my lord, on the last day, Mr. Abrotus Munjumdar, my lord, he took time, but he wanted to give a comprehensive reply to your lordship, my lord, so that, my lord, how this scheme can be
Where
worked
is
out
he?
at all.
Yes.
My lord, he is stuck up since yesterday evening at Delhi airport, my lord, because of this outage, my lord, he couldn't come to Calcutta. My lord, all flights are, my lord, down today. My lord, even yesterday, my lord, he wanted to come in the morning, but couldn't make it out.
We'll keep it next Friday.
Next Friday, my lord.
It is submitted by learned counsel for the insurance company that the learned senior advocate appearing on behalf of the said company, and he's on behalf of the state.
Lord, my lord, it's on behalf of the insurance company.
That the learned senior advocate appearing for the said insurance company is stuck up due to technical glitches and is stuck up for due to unavoidable circumstances. So accordingly, on the prayer of the insurance company, the matter is adjourned till December 12, 2025.
Extremely grateful to you.
Thank you. Matters are
Item number 25.
Appearance.
ওই ওই যে অর্ডারটা হলো on November 28, 2025, when the matter was last called on for hearing, none had appeared to move the contempt application. Even today, none appears at the time of call. Accordingly, CPN 1909 of 2024 is dismissed for default without an address to costs.
Number 23.
Lordship, item number 26, I appear for the contemners. Mr. Sinha Roy is in the matter. I'm trying to get in touch with him, Your Lordship. I'm not being able to get in touch with him. I apologize. He was supposed
Who is appearing?
Mr. Sinha Roy, on the last, when he had admitted, when we had to admit the contempt, Your Lordship had heard him out. He was, Your Lordship was
You are for the petitioners.
No, my lord, I am for the
contemners.
You are for the petitioner.
Yeah, I'm for the yes, Your Lordship. He had argued the matter where Your Lordship, if Your Lordship will remember, this relates to the CPP matter against Port Trust. Your Lordship had asked Mr. Sinaroy to differentiate between civil contempt and criminal contempt. I had spoken to him yesterday. He was supposed to be present over here, Your Lordship. I'm not being able to get in touch with him, Your Lordship.
So then we are adjourning for the day. What can we do?
I'll be grateful for that,
Thank
Your
you.
Lordship.
On the prayer of the petitioner, the matter is adjourned for the adjourned till December 12, 2025.
I'm deeply obliged, Your
Thank you.
Lordship.
Lord, the contemners, I represent the contemners.
Yes, your name will be recorded.
Then, Your Lordship, their appearance.
Yes.
Item number 27.
Grateful, my lord.
Lord, I appear for the my lord petitioner.
Yes.
This was my vacating modification and
The new glasses look good on you.
I'm good.
Yes. Yes, Mr. Datta.
My lord, Lordship had the occasion to pass an order.
This contempt is appearing for the first time.
This is not a
contempt,
my lord. This was an application seeking modification and or variation of an order passed by your Lordship. And Lordship was pleased to pass an interim order in this.
The application.
Application is, my lord, it has other applications also. Lordship has passed an order in there is an order of 18th of September 2025 in the modification application. But Lordship has permitted them to use affidavit. We have not been, my lord, served with any affidavit yet from the consumers.
Affidavit to the application?
To my application. If your Lordship kindly takes.
Your application is can?
Let
me just check it.
Actually, there are too many cans, my lord, in this.
Yes, yes.
My lord,
when was the order passed?
My lord, 18th of September, my lord.
September.
18th of September. There should be a can 3 of 2025. That's the most recent can, my lord. That's the, my lord, last application which Lordship had the occasion to consider.
Did I direct affidavits? I can't find that.
My lord, paragraph 29, internal
29.
page 12, my lord. And many consumers, in terms of your Lordship's order, have not yet furnished the checks which they were supposed to, my lord, furnished, my lord, lordship had provided for an arrangement in terms of a division bench, my lord, a coordinate bench, my lord, order passed by my lord the division bench presided over by the then Chief Justice. Following that, lordship modified the order because otherwise they were getting, my lord, or enjoying a blanket order of stay.
that, yes.
That is the reason why lordship followed that judgment, which had followed a previous Supreme Court, my lord, directive.
Yes.
And my lord, in terms thereof, my lord, lordship had provided for an arrangement. Many of them, my lord, I am told, my lord, that they have not even complied with this direction of furnishing, my lord, checks as security till such time they, my lord, give the bank guarantee for the balance 50%. But that 3-month period has not yet expired. So lordship can extend this and keep a very short date before the vacation if I get one more opportunity, at least to, my lord, see the conduct, my lord.
For the affidavits in opposition, I'll extend the time for a week.
For a week, my lord, yes.
For a week.
Now that will give us, my lord, time to come back before the vacation, my lord.
Yes, that is what.
Yes.
None appears for the writ petitioner stroke respondents in the vacating applications at the time of call. Full comma, although the DVC is represented through counsel. Next para. It transpires that by an order dated September 18, 2025, comma, affidavits were directed to be filed in respect of the vacating applications which have not yet been complied with, Full stop. Next para. The time for filing affidavits in opposition to the vacating applications is extended till December 12, 2025. Full stop. Next para. The time for filing reply thereto is extended till December 19, 2025, when the matters shall next be listed for hearing under the same heading.
And I shall, my lord, communicate this order to the, my lord, advocate who was representing, my lord, the
learned advocate on record for the vacating applicants is requested to communicate this order to the learned advocates on record appearing for the writ petitioners stroke opposite parties in the vacating application.
Grateful.
In the meantime, just communicate a server copy.
Grateful.
Item number 50.
Right, please, your lordship. My lord, I'm for the petitioner. Last matter and
yes.
For the added respondents, my lord.
Lord, the enforcement directorate represented by Mr. Chakraborty. There, I do not believe they're here. We have filed our written notes.
Which Mr. Chakraborty was appearing?
Mr. Orijit Chakraborty for the enforcement.
Yes.
Oh,
my lord, kindly take up the matter. He's coming.
Very good. I've taken up.
My lord.
He was submitting, Mr. Chakraborty.
My lord, we had submitted our written notes of argument.
Oh, written notes of argument. Yes.
For the petitioner.
Written note of argument is ready, man.
Very good, then file it. Ready, but in the wrong hands. Because Mr. Chakraborty is not here. These are your notes of argument.
This is what I believe was submitted at the time of the hearing for interim order. There was a shorter list of dates that shorter
written notes. Please just check up whether it's here. But don't change the chronology.
Okay. আমরা 21st নভেম্বরে আমরা রেকর্ডেড আছে অর্ডারে যে আমরা সাবমিট করছি
এখানে ওহো সরি এর মধ্যে একটা নো দিস রাইট সরি মাই মিস্টেক এখান থেকে যেটা লাগবে
think so. I can address if your lordship wishes.
Just remind me in a nutshell.
Petitioner number 1 is a company.
Yes.
Petitioner number 1 is a company. There are disputes between the brothers who were earlier involved in the company. Now it is exclusively mine from 1996.
Mr. Ramesh was one of the brothers.
I am for all the petitioners. Ramesh Kumar Kejriwal, Ankit Kumar Kejriwal, all directors in petitioner number 1 and 2.
One of the brothers
Yes. So
was castigated by
earlier there was a shareholding that the added respondents had.
Oh, you are for that brother?
Yes.
For that brother, his wife and son. They are the people implicated.
Oh,
Their
that's
property
very
has been identified in the notice. It has
Yes.
identified that the trail of money is going from Mahesh's company, from this LIC policy to Mahesh's
Oh,
company.
that identity model was passed.
Except my property, where he is a disputed shareholder.
You would be happy with that identity model
Being confirmed.
being confirmed.
That was our limited submission. Lordship had dealt with all the questions.
What was the date of that order?
26th September 2022. Perhaps separately, I didn't find it in the file. I can hand your lordship the interim order, but it is marked, my lord.
No, I'll just check up. 26 September 2022. Yes, I have it. Yes.
If I may take your lordship through the order.
Yes. It was segregated and something was.
Yes, my lord. The proceedings were stayed before the PMLA authorities. Your lordship's findings, para 28 onwards. Ours was on a simple fact that you're a shareholder, you have no right in the assets of the company. Bacha Gazdar and all the judgments following it.
Yes, right.
That you may have been a shareholder, property belongs to the company, purchased in 1950s by the company.
The allegations were against the company. And
No, only against
only
the
against
added
Mahesh.
respondents. And because of their shareholding in my company,
Yes.
where they have no control, only a disputed shareholding of some
The assets of the company probably were.
That was attached.
Attached.
And that portion, they are saying that Mahesh Kumar Kejriwal, Alka Kumar Kejriwal together hold 10%, which is disputed, cancelled by CLB's order, which is pending in challenge.
That you have put in a written notes also.
Yes. All the page numbers are there. Even the finding is to the effect that the money is going to his other companies, except no question of my company. At the time of attachment, they say you have 10% shareholding in Sri Hanuman Cotton, petitioner number 1. Therefore, we are attaching your. Totally perverse.
What is your stand in the matter?
I'm led by Mr. Jishnu Shah in this matter.
You have not even challenged, so you are added respondents. So you don't have any say as such. An adjournment is a short adjournment is sought on behalf of the Enforcement Directorate at the time of call, full stop. However, even after waiting for some time, the Enforcement Directorate.
Both are here.
Both are not. We are not interested in both. Only you.
Yes, madam.
Yes.
My written notes.
You take your breath and
my
written notes are to be filed.
ready, madam. Coming on the way.
We can give you leave to file during the course of. Yes, with my officer.
Yes, madam.
Verbally,
verbally, two things I.
Yes, you address me verbally, and in the meantime,
yes, it will reach. It will reach by that time. Malad, the only thing your lordship will find,
yes,
from your lordship's interim order, that your lordship had passed an order of stay on the. Malad, there are 3 parts of provisional attachment. One part is proportionate portion of the property of petitioner number 1.
Yes.
To the proportion of the share holded by the
Mahesh.
Accused persons and his wife. And his wife. So and the second part is the share. Third part is an office in the name of Mahesh. Now, your lordship had in the interim order said that the proportionate part cannot be because it is settled position of law that shareholders are not there.
With my learned friends, leave me, Lord. On 2 and 3, I have nothing to say.
Yes, obviously, because that
I have nothing to say.
Did I state that?
No. Your lordship has not.
Cannot be.
Nothing to say there.
Very well. So on the first part, your lordship said that
Mahesh's shares is obviously have a right, and regarding his office also.
Right. So that part your lordship has not stated. Your lordship only state the property, that property.
Bacha Gazdar principle.
That property.
Shareholder.
Property. Because shareholders cannot be owner of the property. My lord, perhaps during that interim motion stage, my lord, I was not clear before your lordship that it was not seized or attached by holding that he is owner of that property. Why it was attached, your lordship considered in the latter part when order was passed, I prayed, that Our only apprehension is that, my lord, our duty is to find out the proceeds of crime.
Absolutely, yes.
And to realize it. Now, my lord, a shareholder is not the owner of the property of the
Does
company.
not have any right in the assets of the company,
Correct.
to be
does,
precise.
does not have any right in the assets of the company. But if today, tomorrow, or at any point of time, the assets are liquidated, then the shareholder will get the amount of liquidation proportionate to his share.
Isn't that too remote, Mr. Chakraborty?
No, yes, it's
Doesn't
remote.
it appear to yourself
No,
also
no,
to
it's,
your ears?
no, it's too remote.
If that is done, definitely you have a right to.
That is what.
Yes,
is
if,
our
if
only.
it happens, definitely, because Mr. Chakraborty, obviously, if it's a CIRP or some other process, you are entitled to go there.
Go and make application.
Yes.
Well, only one humble.
You are
prayer.
entitled.
Only one humble prayer before your lordship. Why we attached it provisionally, which has been stated by your lordship, that we don't want that property to be liquidated, and tomorrow we can't realize that part of proceeds of crime.
That's a typical paranoia of all investigating agencies. But we appreciate that, because when you go to enforce the law, you find that ultimately the culprit has slipped away.
Correct.
We fully appreciate
Well,
that, Mr.
only one
Chakraborty.
prayer before
Court's
your lordship.
intention cannot
Your
be
lordship.
to let the lawbreakers go away.
If your lordship.
But you have to have he has to have some right,
Right.
for you to attach.
Right. What only one humble prayer, subject to what your lordship decides. The only humble prayer. Go and find it out. George, sir, wait for me. Well, only humble prayer before your lordship today is that let the attachment or provisional attachment, as indicated by your lordship, go from the property of petitioner number 1. Let it go. But let there be one subject from your lordship, that if petitioner number 1 wants to liquidate any property of the company, they will at least inform or any proceeding to the enforcement director. They are not any of our accused. Petitioner number 1 is not the accused. Your lordship will appreciate. We have no access to him. If
Can
your
we
lordship,
put that fetter on the petitioner? We are thinking about that also.
only they will intimate us that it is going, that a CIRP is going on, or they will put us on notice so that we can take steps. Otherwise, my lord, it will be very difficult. My lord knows in this vast country, it is very difficult who is going into which.
With your resources, Mr. Chakraborty, you can keep a tab on the company. Who prevents you?
That is what we wanted to do.
Peep from outside the window, but don't come into the door.
My lord knows the law. Section 5 we have done. My lord knows Section 5, subsection 9 says that even
your hands are sufficiently wide to just keep a track of the company's this thing.
Sometimes it becomes very difficult, my lord.
For ED, it should not be. Your job is this, Mr.
Right,
Chakraborty, and your resources are much more than
this is my
normal people.
This is humble prayer, my lord.
They even keep a tab on their advocates nowadays. You also be careful.
Well, that's not. That is why Malad knows provisional attachment. After even a provisional attachment,
Can we do that? Can we ask a company to, intimate whenever
Malad will kindly appreciate.
You want to cooperate in that regard, Mr.
Yes, I have no.
Then we'll record that and.
Yes, Milord, I give an undertaking on behalf of my client that if the petitioner number 1 is admitted for CIRP, I will remain, Milord, personally responsible to inform the ED.
You cannot remain personally responsible because you are a company.
No, I'm sorry, Milord. Second petitioner, Milord. Third and fourth petitioner, Milord.
No, the company also then. Both all the
company, Milord, if admitted into.
Oh yes.
Oh, actually not, Milord. Actually not. The RP can be told, but your lordship can also make us responsible.
Yes, if you are responsible.
Milord, 3 and 4. Milord, we will inform them. We have nothing. Milord.
Correct. That's not what I pray. What?
I'll inform them if there is not property sold. Inform them if we are admitted into CIRP.
Or any liquidation process.
Or liquidation. Liquidation comes after CIRP.
Definitely.
So if the petitioner number 1 is admitted into CIRP, the petitioner numbers 3 and 4 will inform the enforcement directorate. I have also filed a writ petition against them, saying that why have you...
that is also pending before...
Why have you proceeded against me? I have given them a full list of properties of my brother. He's got 1,000 crore plus companies.
They are also appearing before your lordship as added respondent.
What was the, let me check up the ordering portion of the interim order.
Malak, kindly take para 55.
Of that order.
Of that order. 26/9/2022.
Paragraph 55 and 56. And Milord, my further case, I should tell your lordship, Milord, is that the shares were transferred to my client, which is what, Milord, Mahesh challenged before the Company Law Board in 2006. And I have succeeded before the Company Law Board. And Mahesh has filed an Section 10F appeal, which is being heard on a regular basis. So my contention is both father's shares and Mahesh's shares transferred to me under the family settlement of 2002, 96 and 2002. And my lord,
The
Mahesh
transfer was immediately prior to this or after this? After this investigation?
Prior.
Much prior. This is all in the.
But he says there was a transfer. Mahesh says there was no transfer. They went into the company law board.
And
Company
Mahesh
law
lost.
board decided in his favor. Mahesh filed an appeal, which is pending. All are recorded in the lordship interim.
That is, and plus Mahesh has also, filed a contempt to break down the factory. He has also filed a writ petition to break down the factory. We are on the best of terms.
So, yes.
We request my lord not to make any observation with regard to these allegations. We are filing application. Not only I have challenged the order passed by the learned CLB, but my learned friend's client Ramesh has also filed challenge the same order.
Yes, against grandfather.
No, we are not going into that chapter at all. This is just for information, Mr. Chaudhary.
No, I want, because if your lordship says that regarding the shares attachment
We'll
can
modify the
continue.
order of provisional attachment and the show cause notice to the extent that interim order was granted. That
Yes,
portion,
yes.
that part.
Yes, yes.
Now we'll dispose of this writ petition and I'll just modify the impugned order and the show cause notice to that extent.
Because if
as far as your
as the way I look at it, if he succeeds in the 10F appeal and the shares go back to him, let them be attached.
no, whatever goes back to him.
I would only humbly submit kindly deals with only the subject matter of the writ petition because any observation made by my lord may be used adversely against me in other proceedings. I'm not saying that is why I've not even filed a note. My only submission is the allegations made against the private respondents who were not initially made party respondents. We had to file an application for addition. Those my lord will not.
Then there would not be any use of filing written notes of arguments by you. If you see, if I record that argument.
But submitted before your lordship, I have made only that much. This is meant for the court only, not for you.
No, give copies.
My lord, everything should not go to the bench. It's between the bar. Definitely.
When you're doing virtual hearings, your lordship would not be aware. But even when your lordship speak to each other, it's not audible here, but it's audible on the virtual mode.
Is it?
Yes. Because of the camera. Because
But I have
so many
appeared.
things said.
And the mandatory switch of the microphone while they that also.
Once I was arguing and I discovered the fate of my argument when the learned senior judge told the learned junior judge that my argument was totally meritless. Yeah, of course. Please, dear Lord.
No, but you have in your written notes you have argued on merits also.
No, not only.
The petitioner number 1 herein being person within the scope of 2(1)(s) PMLA.
But that's I have indicated the fact only.
The respondent number 2 herein has rightly attached provisionally such proportionate part of this.
That is always my submission.
That is what we are saying. I'm saying that it is not that you have whatever you have submitted.
But that was always my standpoint before your lordship that the attachment was correct on the understand manner.
You can't record these written notes of arguments, but record your submission, verbal submission.
Well, kindly see. I have seen. I have written over here.
Yes.
That
para 6 last line.
Yes, my lord, kindly see. I have said that the purpose of provisional attachment was only to stop the alienation of the property. Only that much. We have never considered him to be owner of the assets of the company. Kindly see. My lord, kindly see this paragraph 6. Sixth sentence starts from right hand side. Eat. Well, 6th line from the top starts with it. It is was never the case of the respondents that accused Mahesh Kumar Kejriwal and or accused Alka Kejriwal being shareholders or owner of any asset of the petitioner number 1. It humbly submitted that 5.1 authorizes respondent number 2 herein to provisionally attach any property when it is found that any person is in possession of any POC and such
liquidation
POC is
and all.
likely to be concealed, transferred or dealt with in any manner which may frustrate the proceeding relating to confiscation of such POC. Admittedly, accused persons above named are holding total such and such shares. As such, any liquidation of the assets of the petitioner number 1 herein will generate amounts to the said accused persons in proportion to their said shares, which is liable to be confiscated at POC under PM. But this is my case.
The written notes of arguments filed by the Enforcement Directorate today be kept on record. First of heard learned counsel for the parties. First of next para. Learned senior counsel appearing for the petitioners draws the attention of the court to the order to the interim order dated September 26, 2022, where the facts and the law of the matter was discussed at length, and an order of injunction was passed to a limited extent insofar as the petitioner number 1 company is concerned. First of next para, it is submitted that the petitioners seek the said order to be made absolute. First of next para, learned counsel appearing for the Enforcement Directorate submits that the premise of provisional attachment of the assets of the assets of the petitioner number 1 company was never that the accused Mohesh, the added respondent, was an owner of the assets of the said assets. Full stop. However, since the Enforcement Directorate apprehends that the accused persons, that is the said Mohesh and his family members, hold a total of 1793 shares in the petitioner number 1 company, any liquidation of the assets of petitioner number 1 would generate amounts of money to the said accused persons in proportion to their said shares, which would be liable to be confiscated under the PMLA. Full stop. Next para. On such premise, it is argued that the provisional attachment order in respect of the assets of the company to the extent of the shares of the accused persons was justified. Full stop. Next para. It is further submitted that the petitioner number 1 company may be the petitioners may be directed to intimate to the Enforcement Directorate, in any event, if the company goes into liquidation, since such liquidation process may ultimately culminate in liquidation of Mohesh's liquidation of the amount quantified in proportion of Mohesh's of the accused person's shares to be disbursed in their favor. For some next para, learned counsel appearing for the added respondents submits that since the investigation is still ongoing, this investigation is ongoing, or you have filed a charge sheet?
In our case?
Yes.
In our case, investigation charge sheet filed.
Since the criminal allegations against the added respondents are sub judice, no adverse remarks may be made conclusively against the added respondents. Push up next para. Upon consideration of the facts of the case, it transpires that the petitioner number 1 is a company which granted lease in respect of a land to the petitioner number 2 company, and the petitioner number 3 is the director of both the said companies. Full stop. Petitioner number 4, the son of petitioner number 3 is a director of the petitioner number 2 company, whereas petitioner number 3, Ramesh, has a brother by the name of Mahesh. Full stop. Next para. Since it is well settled in law that shareholders are not the owners of the company in which they hold shares and stroke or the assets of the company, comma, it is evident, comma, by borrowing the logic as recorded in the interim order dated September 26, 2022, that the show cause notice dated May 5, 2022, issued by the Enforcement Directorate and the
Sorry to interrupt. Show cause notice issued by the adjudicating authority.
sorry. The show cause notice issued by show cause notice issued by the adjudicating authority and the provisional attachment order dated March 31, 2022, were bad in law inasmuch as the land belonging to the petitioner number 1 company as mentioned therein is concerned. Push up next para. Accordingly, comma, upon hearing learned counsel for the parties, comma, and in view of the submissions made, comma, WPA 17513 of 2022 is disposed of by modifying the impugned order of provisional attachment dated March 31, 2022 and the impugned show cause notice dated May 5, 2022 to the extent that the same concerns the land admeasuring 25.39 acres at Fuleshwar in JL number 108, RS number 2277 of the petitioner number 1 hyphen company within bracket as mentioned in serial number 1 of table 8 of the impugned order dated March 31, 2022, bracket close, is set aside. Push up next para. In the event any adjudication has been arrived at under section 8 of the PMLA before passing of this order, but after filing of the writ petition, comma, the said order is also set aside to the consequentially set aside to the above extent. Full stop. Next para. However, comma, it is made clear that insofar as the 1793 shares of the petitioner number 1 company within bracket 1025 in the name of Mahesh Kumar Kejriwal and 768 in the name of Alka Kejriwal, comma, his wife, bracket closed, comma, as specifically stipulated in table number 7 of the impugned order dated March 31, 2022 under section 5 within bracket 1 of the PMLA are concerned, comma, and the office room purportedly standing in the name of Mahesh Kumar Kejriwal is concerned, comma, as mentioned in serial number 2 of table 8 of the impugned order, bracket, being office room number 12 measuring about 612.49 square feet within bracket super built up, bracket closed, approximately, and false ceiling on the 5th floor of the building situated at premises number 12 capital A, comma, NS Road, comma, Kolkata 7,01,000 is concerned, comma, nothing in this order shall prevent the enforcement respondents from acting in terms of and stroke or in pursuance of or in implementation of the impugned order and show cause notice and or of any adjudication under section 8 of the PMLA made consequent thereto. Full stop. Next para. It is further clarified that the petitioner numbers 2 and 3 shall, comma, in the event the petitioner number, the petitioner number 3, the petitioner number 3,
3 and 4, Miller.
3 and 4, petition numbers 3 and 4 shall, comma, in the event the petitioner numbers 1 and 2 or 1.
1.
Petitioner, in the event the petitioner number 1 company undergoes any liquidation process, comma, including any corporate insolvency resolution process, comma, inform such fact immediately upon commencement of such proceeding to the Enforcement Directorate in writing. Full stop. Next para. It is further clarified that none of the above observations or the observations made in connection with the orders passed in the writ petition shall be deemed to adversely affect the outcome of the criminal proceedings going on against the added respondents and stroke or be construed either in favor of or against the said added respondents insofar as the criminal allegations against the added respondents are concerned. No rest to cost, yes.
One more indulgence, may I?
Yes, yes.
Well, the setting aside of the part of the provisional attachment will not stop the enforcement directorate to go for any further provisional attachment with respect to the accused persons. If
Yes,
any.
yes, of course.
Well, tomorrow,
Of
well,
course.
they are- why
I hope you say this in my writ petition.
Well, why I say this? Why I say this, my lord? That goes without saying. I also know, as my learned junior
Yes,
friend said.
goes without saying.
My lord, tomorrow, if any fresh provisional attachment is made with respect to any other property, they may come before the court with the or any other authority with this order saying that, see, once it is set aside by the court, then they have gone into for this. Earlier, they have not done that.
Nothing in the, needless to say, nothing in the above order shall prevent the enforcement directorate from initiating any further investigation against the accused persons in the event the enforcement directorate is otherwise so entitled in law, in due process of law.
Deeply obliged.
One request from me, Lord. Now, I will contend, and I am contending today, that out of this 1793 shares, 1025 shares don't belong to Mahesh anymore. Halka's shares are her shares. They can be attached. But that, my lord, is where I permit me to make this argument.
That question is pending
That
before
yes, pending before 10F court.
This is not a fact-finding court, so I would humbly submit not to make
No,
any
please, my lord,
observation with regard to
No,
this.
because
you can
we
leave it open. Otherwise, I can't contend before ED that this is not Mahesh's shares.
My lord may keep it open for the outcome after the outcome of the
yes. Arekta line add করুন, since the ownership of the aforementioned 1793
1025
1025 of Mahesh.
Achha, since the ownership of 1025 shares allegedly belonging to the accused Mahesh is in contention before the appropriate forum, in a proceeding between the petitioner numbers 3 and 4 and the added respondents, it is made clear that that it will be open to the petitioners in the event the said shares are adjudicated ultimately to belong to the petitioners, to approach the enforcement directorate for the purpose of release, enforcement directorate and or the adjudicating authority or any competent forum for release of the said shares from the ambit of the criminal proceeding.
Deeply obliged. The last word, competent forum, was very much required. Because
Yes, it can be.
Otherwise, by that portion of time,
Yes,
may
it will
go to
reach.
tribunal or to the special
Exactly,
court.
exactly.
So that will help him.
Absolutely, Mr.
Deeply
Thank,
obliged. Milord.
thank you so much. Thank you for the fair stand. No, actually, I mean,
it's
cut shorts unnecessary litigation.
Correct. Otherwise, no, I will not gain anything.
Exactly. I mean, it's an obvious proposition of all of us know.
I was telling him we hope to see more convictions. These matters, my lord, after charge sheet don't proceed before the verdict.
Senior friend that if I remain in the panel for next 2 years, there will be convictions at least in 10 cases.
Yes, because otherwise a wrong impression goes that you are being used for other purposes.
I tell your lordship has the occasions or the experience to say. But whenever the number of accused are much, the trial takes much time.
Obviously.
Because, my lord, for the old provision of CRPC, there was no limitation for discharge petition. But even after 3 years, 4 years, when the charge is to be taken up by the learned trial court, that one person will come up with a discharge petition. Now under BNS, it is made 60 days from the date of filing.
Yes.
Now there is a limitation.
It will be easier for.
Otherwise, my lord, kindly visualize, I am facing 37 accused persons in a case. For last 7 years, discharge petitions are going on. One after another. One get disposed of in 5 months. Then the next one come on the next date.
Because ultimately, if certain persons are accused, also it works the other way. if they are found ultimately not to be guilty by you at the end of the investigation, they also get discharged. They get a bad name in the
Exactly. So they want
and the credibility of it is also, I mean, it's
So,
a
my lord,
very
now-
important thing for the country, in fact.
But I tell you, Lordship, because of the intervention of this honorable court or honorable high courts or honorable Supreme Court in series of matters, now the trial courts are also not entertaining this kind. Whenever one person come with a discharge petition, there is a regular trade now. We made it. We have tried to do the convincing. The trial court is passing an order that I'm keeping the matter on such and such date. Whichever accused person comes on a discharge
Open,
petition, they have to file it on that very day, so that all dispositions can be. But this is one step. Now a new problem came in above our head is precognizance hearing.
Precognizance, yes, I have held in a matter against
I had the
you were there,
My lord,
but there was no other option in the law. I mean,
I know.
Has that order been challenged?
Cannot be.
Because it's, I mean,
Your lordship's order, my lord.
my orders are regularly challenged.
Yes,
That's a wrong notion.
Live stream goes on. Your lordship's order, I read and I personally felt much more higher and complete.
Take a microphone and tell it. Yes, I want more footage on the live.
Very well. My lord, your lordship's order on the precognizance hearing was complete in nature. So, my lord, now your lordship will see the precognizance hearing, same thing is happening again because no limitation.
Because of the law.
Because of the law. Nowadays, we are stuck at the earlier stage. Now we are trying. We are trying our level best.
No, the other stages you have been given a, I mean,
time limit.
Yes, time limit and flexibility.
Become open.
That is all the more necessary, probably because you have got a flexibility in the later stages.
Your lordship,
at the outset,
your
otherwise that
lordship,
is
while considering that, your lordship was thinking that there are actually two kind of complaint cases. What I tried to project before your lordship, one is private complaint. To have a check and balance on the frivolous private complaints, probably the legislature enacted that. But my lord, so far as complaint cases under any fiscal statute, your lordship will be Custom Act complaint case.
Yes, Mr. Raju argued that actually.
Yes.
Yes.
My lord, what is happening? My lord has taken the correct view because the second proviso give a waiver specific with respect to that. But the first proviso does not give. So by law, we have to go.
If the law is amendment, then we are bound by that.
Correct.
Yes.
I hope that it get amended. I hope.
So you are on the panel.
No, that waiver.
You go to the other side.
To understand what is happening, I'll have to borrow my son's textbooks. I have no idea of all this.
Don't worry. It will take 5 minutes for you to understand if Mr. Chakravarti.
2 minutes he will take.
2 minutes. 2 minutes. Thank you very much.
Great.